Mention tomorrow. No.
Supplementary daily. Item number 7.
Under the order of this Honorable the IAC.
Just a minute. Yes.
Yes, the IAC is present in person. The SP is appear through DC.
Where is that?
The report of the Superintendent Police.
You're asking to appear to.
Please join. SP Malkanagiri, please join.
Then, sir, I've joined in VC.
Open your.
Video is open, sir.
Yeah.
शो को जो
Just a minute. in the operative part of the order dated 2011-2025, we asked the IAC to appear before us. So the IAC is present in person, and SP Police Malkangiri to appear through virtual mode. So he is present.
Next part.
IAC of Model Police Station shall ensure the appearance of both the appellants so and so through virtual mode. What happened to this? ଆଉ ଟିକେ ଆଗକୁ ଆସନ୍ତୁ ଏଟା ଅନ୍ ଅଛି ତ?
पुलिस ତାଙ୍କୁ ନୋଟିସ୍ ଖୋଜି ପଚରାପଚରି ଆଉ ଘରକୁ ଯିବାରୁ ଆଉ ସେମାନେ ଫେରାର ହେଇଛନ୍ତି ସାର୍। ଲାଷ୍ଟ ଟାଇମ୍ ତାମିଲନାଡୁରୁ ଥିଲେ, ଆସୁଛୁ କହିଲେ ଆଉ ଫୋନ୍ ବି ସୁଇଚ୍ ଅଫ୍ କରିଦେଇଛନ୍ତି ସାର୍।
ନାଇଁ ତାଙ୍କ ସାଙ୍ଗରେ ଆପଣ କଥା ଯୋଗାଯୋଗ କରିଛନ୍ତି?
ହଁ ସାର୍ କରିଥିଲୁ ସାର୍, ଆସୁଛୁ କହିଲେ ଆଉ ଆସିଲେନି ସାର୍, ଫୋନ୍ ସୁଇଚ୍ ଅଫ୍ କରିଦେଲେ ସାର୍।
ଆଚ୍ଛା
ଆଉ ତାଙ୍କ ରିଲେଟିଭ୍ ମାନଙ୍କୁ ବି କହିଲେ ଆସନ୍ତୁ ଭିଡ଼ିଓ କଲ୍ରେ ଦେଖା ହେଇଯିବେ, ଆଉ କିଛି ଏଠି ଅସୁବିଧା ନାହିଁ କହିଲା। ସେମାନେ ଡରୁଛନ୍ତି ସାର୍, ପୁଲିସ ଆରେଷ୍ଟ କରିଦେବ ନା କରିଦେବ ଭୟରେ।
ନାଇଁ ଆପଣ ରିପୋର୍ଟ ଆଜି ଯାହା ଦେଇଛନ୍ତି ବା ଯେ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଅଫ ପୋଲିସ ଯାହା ଦେଇଛନ୍ତି ସେଥିରୁ ଜଣା ପଡୁଛି 2 ଜଣ ଯାକ ବଞ୍ଚିଛନ୍ତି।
ସାର୍
ନମ୍ବର 1 ନମ୍ବର 2 ସେମାନେ ଜଣେ ତା ଦେହରୁ ସେ ସଞ୍ଜିତ ଯିଏ ସେ ଗୋଟେ ଟ୍ରକ ରେ ହେଲ୍ପର ହିସାବରେ କାମ କରୁଛି, ଆଉ ତାର ସ୍ତ୍ରୀ ଗୋଟେ ଡେଲି ୱେଜ ଲେବର ହିସାବରେ କାମ କରୁଛି ହେଲା, ଏବଂ ସେମାନେ ତାମିଲନାଡୁରେ ବର୍ତ୍ତମାନ ଅଛନ୍ତି।
ସାର୍
ଏଇଆ ରିପୋର୍ଟ ଆପଣଙ୍କର।
ତାଙ୍କର ଭିଡିଓ କଲ୍ ରେ ସେମାନେ ଆପଣ ଦେଖା ସାକ୍ଷାତ ହେଇଥିଲା? ଭିଡିଓ କଲ୍ ରେ ଦେଖା ହେଇଥିଲା?
ସାର୍ ତାଙ୍କୁ
ଆପଣ ଲାଷ୍ଟ ଟାଇମ୍ ଯୋଉଟା କହିଥିଲେ କିଏ ଜଣେ ଘରେ ଥିଲେ ବୋଲି?
ହଁ ସାର୍, ଫୋନରେ କଥା ହେଇଥିଲି ସାର୍ ତାଙ୍କ ୱାଇଫ୍ ସହିତ।
ନାଇଁ, ତାଙ୍କର ତ ବୁଢୀ ମା
ତାଙ୍କର
ଥିଲେ
ମା
ଏବଂ ସେ ଫୋନ୍ ଲଗେଇଦେବାରେ ଆପଣ କଥା ହେଇଥିଲେ?
ନାଇଁ, ତାର ମା ସହିତ ଭିଡିଓ କଲ୍ କରିଥିଲି।
ନିଜେ କଲ୍ କରିଥିଲେ?
ଆରଥରକ ଯୋଉଠି ରହୁଥିଲେ ଶାଶୁ ଘରେ, ମାନେ ଆପେଲାଣ୍ଟର ଶ୍ୱଶୁର ଘର, ଆପେଲାଣ୍ଟ ଟୁ ଲେଡିଙ୍କର ସେ ହଉଛି ମା। ଏ ଲେଡିଙ୍କ ସହିତ he was contacted over phone. He was
that is
assured
what.
to come but did not come because with an apprehension that police may arrest.
So how you will ensure the presence through video even? Because we want to make it rest assured that they are the appellant. In view of this contradictory statement from your side, and since you have also personally not seen them.
ଆପଣ ନିଜେ ତାଙ୍କୁ ଦେଖିଛନ୍ତି କି?
ତାଙ୍କ ସ୍ତ୍ରୀ ଆସିଥିଲେ ସାର୍।
କାହା ସ୍ତ୍ରୀ?
ସେ
ଯୋଉ ଆପେଲାଣ୍ଟ ଥାନାକୁ
ଆସିଥିଲେ,
ଆମେଲା ବାରୋଲ
ଆସିଥିଲେ
ଆମେଲା ବାରୋଲ କୋଉଠିକି ଆସିଥିଲେ?
ଥାନାକୁ ଯେବେ ଖୋଜା ହେଲା ସେ କହିଲେ 20 ତାରିଖ ଆପଣଙ୍କର ଏମିତି ଅଛି କହିଲେ, ତମର ସ୍ୱାମୀ ସହିତ।
ସିଏ ଆମେଲା ବାରୋଲ ବୋଲି ଆପଣଙ୍କୁ କିଏ କହିଲା?
ସେ ତାଙ୍କର ଲୋକାଲିଟି ସାର୍, ଯୋଉ ତାର ମା ରହୁଛି
ଲୋକାଲିଟିରୁ ତାଙ୍କ ମାରୁ ଆପଣ ଇଏ କଲେ ଯେ ଆମେଲା ବାରୋଲ। ଆମେଲା ବାରୋଲ ଆପଣଙ୍କୁ କଣ କହିଲା?
ସେ କହିଲେ 20 ତାରିଖ ଏମିତି ଡେଟ୍ ଅଛି, ମୁଁ ଆସିବି କହିଲା। ତାପରେ ତା ଫୋନ୍ ନମ୍ବର ବି ଆମେ ଯୋଗାଯୋଗ କଲୁ, ନାଇଁ ଏତିକି ତାରିଖ 20 ତାରିଖ ଆପଣଙ୍କର ଡେଟ୍ ଅଛି, ଆସିବାର ଅଛି, ମୁଁ ଆସୁଛି କହିଲା। ତାପରେ ଫୋନ୍ ସୁଇଚ୍ ଅଫ୍ କରିଦେଲେ।
ସେ କହିଲା ତା ସ୍ୱାମୀ ବଞ୍ଚିଛି ବୋଲି?
ହଁ
ଯୋଉ ସଞ୍ଜୀବ ସଞ୍ଜୀବ
ସାର୍, ଆଉ ଗାଁ ଲୋକ ବି ଦେଖିଛନ୍ତି ସାର୍।
ନାଇଁ, ଥାନାକୁ ତ ଆସିଥିଲା ବୋଲି ଆପଣ କହିଲେ।
ହଁ, ତା ସ୍ତ୍ରୀ ଆସିଥିଲେ, ଆମେଲା ବରେଇ ଆସିଥିଲେ।
କେବେ ଆସିଥିଲା ତା ସ୍ତ୍ରୀ?
ବିଫୋର 20 ତାରିଖ ସାର୍, ଏକ୍ସାକ୍ଟ ଡେଟ୍
ରିପୋର୍ଟ ଦେବା ପୂର୍ବରୁ, ଆଫିଡେଭିଟ୍ ଦେବା ପୂର୍ବରୁ
ସାର୍।
ଫୋନ୍ ନମ୍ବର ବି ଦେଇଛି, ସେ ଫୋନ୍ ନମ୍ବର କଣ୍ଟାକ୍ଟ।
ମାନେ ନଭେମ୍ବର ମାସରେ ନା ଅକ୍ଟୋବର ମାସରେ?
ନଭେମ୍ବର ସାର୍, 20 ତାରିଖ ବିଫୋର 20 ତାରିଖ ତାଙ୍କୁ ଇନଫର୍ମ କରାହେଲା କି 20 ତାରିଖ ଭିଡିଓ କଲ୍ରେ ଆପିୟର ହେବାର ଅଛି।
ଆଉ ଏଇ ଯୋଉ ତା ଫୋନରେ ତା ସ୍ୱାମୀ ସାଙ୍ଗରେ ଆପଣ କଥା ହେଇଥିଲେ?
ନାଇଁ ସାର୍, ଆମେଲା ବରେଇର ଫୋନରେ କଥା ହେଇଥିଲି। ଆମେଲା ବରେଇର ଫୋନରେ କଥା ହେଇଥିଲି।
କଥା ହେଇଥିଲେ ତ?
6370
ଆପଣ ନିଜେ କଥା
ମୁଁ
ହେଇଥିଲେ?
କଥା ହେଇଥିଲି।
You are appearing for them privately, na? You have received the paperwork? Take down. As per the order dated 2011-2025, what is your name?
Regan Kindle.
Regal Kingdom.
ওটা না লেখাই জি
affidavit
হ্যাঁ
last to the affidavit আছে
লাস্ট ওটা affidavit দিয়েছিলেন
আগে
Regan
আচ্ছা
Kingdom.
resign
রিগান RIGN Kindo, the inspector in charge of Malkangiri Model Police Station
Sir.
is present. Similarly, the Mr. So na kono Superintendent Police
Vinod Patil.
Vinod Patil
Vinod Patil, sir.
likhi diyo.
Sir.
Superintendent of Police has appeared through virtual mode. Superintendent Police has filed the show cause notice issued to Kruttivas Behera. This Kruttivas Behera was the SI of police.
Sir.
SI of police, Malkangiri Model Police Station. As to why the disciplinary action shall not be initiated against him for gross negligence and dereliction of duty. He has also filed the explanation which has been submitted by the said SI of police, which is dated 27/11/2025. And a letter dated 29/11/2025, which is addressed to London Advocate General, Odisha, wherein it is stated that taking into consideration the explanation submitted by Sri Kruttivas Behera, SI of Police, his previous conduct and absence of any malafide intention, he has been awarded a warning, which has been duly recorded in his service book for the lapse in duty. It is further stated in the said letter that the appellant number 1, Sanjeev alias Sanjeet alias Sanjeev Mandar, is presently working as a helper in a truck engaged in interstate goods transportation, and he occasionally visits MV03. And his wife, Amela Baroi, bracket appellant number 2, works as a daily wage laborer and occasionally travels to other states for livelihood. And they have now moved to Tamil Nadu for labor works, and efforts are being made to trace and produce the couple. The order passed in respect of SI of Police Kutivas Behra, inverted comma warned in SB, is also produced before us. The document submitted by the Superintendent of Police Malkangiri taken on record. On a query to the IIC of Model Police Station, is submitted that prior to November 20th, the appellant number 2, Amela Barol alias Mandal, appeared at Model Police Station, and he had an through her mobile phone, he also contacted. He also talked with appellant number 1, Sanjeev alias Sanjeev Mandal, and both the appellants, according to his information, are now alive. The personal appearance of the IIC Model Police Station Malkangiri, so also the Superintendent of Police Malkangiri are dispensed with stock. The Mr. J.K. Panda, Land Counsel for the appellant, is present, and he has stated that he has received the paper book. And he is also ready for hearing. So we take up this matter today after we finish up the other orders. Which you may go now. Yes, please wait. All the matters.
We may receive the paper book so that
You have not
received.
Sorry. The London Council for the State submits that he has not yet received the paper book. Let paper book be supplied to the Land Council for the State during course of the day. Matter will be listed on
next hostel.
11th of December 2025 for hearing.
Yes, Mr. Patil, you can move.
Yes, 11. Please copy of the order be handed. 11/12/2025 for hearing.
no bless.
Item 1.
One minute. Open the institution.
In this case on the section so, and at the time of filing charge sheet, they were taken into judicial custody, and they are on Kumar Pradhan alias Nemin and Panchanan Pradhan alias Panchu, and subsequently Vashant Kumar Pradhan alias Basu, who was an absconder as per charge sheet, was also taken into judicial custody. Accordingly, Hemant Kumar Pradhan, Panchanan Pradhan, Vashant Kumar Pradhan faced trial, and Hemant and Panchanan were acquitted of the charges, and appellant Vashant has been convicted under section 3.20G of IPC, and he has been sentenced to undergo RI for life. It is not known as to what happened to the absconding accused persons, Sushant Kumar Mahapatra alias Upuna and Suryakant Mahapatra alias Kanu, against whom the case has been split up. One counsel for the state shall obtain instructions, and the paper book has already been received by Swan. So, this matter on instruction. What has been
Submitted that the absconding accused person Surjakanta
Mahapatra.
Second part.
Yeah.
Second part.
It is only submitted there.
That the absconding accused person Surjakanta Mahapatra alias Kanu, son of Surendra Mahapatra of Kottakhal of PS Niari District Kotak, has been arrested and forwarded to the Honorable Court in the year 2014 on the strength of warrant issued against him. Suryakanta Mahapatra alias Kannu is facing the trial regularly and on being contacted over mobile number, he stated that he has appeared before the Honorable Court first hearing Cuttack on 25/11/25 for hearing, and the next date of hearing is scheduled to be held on date 19/6. Another absconder named Sushanta Kumar Mahapatra alias Sukuna, son of Prafulla Mahapatra of Kosara, PS Union District Court, is still at large. Sushanta Mahapatra alias Sukuna has been remaining absconding to evade legal action. He is present for about 6 hours.
Okay, we are concerned. Actually, we wanted to know about that. So, now this report has come. Let him. Let him do. In pursuance of the order dated 25/11/2025, the Land Council for the state has produced the report dated AK 12/2025 of IIC Niyali Police Station, Cuttack, wherein it is indicated that the absconding accused Suryakant Mahapatra alias Kanu was arrested and forwarded to court in the year 2014 on the strength of warrant issued against him, and thereafter he is facing trial in the court of London First Additional Session Judge, Cuttack, and the trial is on. So far as the absconding accused Sushant Kumar Mahapatra alias Sukuna is concerned, he is still at large and his present whereabout is not known. The written instruction submitted by the London Council for the state is taken on record. So you have received the paperwork now. So argument the matter get. You have also received the paper. Okay, we have to take up this matter, but let us go one by one. The other orders matter we have status report will finish, and then next matter.
Item 2.
Women have obtained instruction and is alive.
Last time also Mr. Srinivas Mahanti didn't appear.
I have intimated.
You have intimated.
Yes.
Where is gone? Please give him a ring so that let him do. Item number 2, CRL number 98 of 2005. The London Council for the State
Single apply. Single apply.
has produced the written instruction dated 1/12/2025 from Inspector in Charge, Daspalla Police Station, that the appellant, the Northern Farida, is now alive and is working as a tractor driver and living with his family. The written instruction is taken on record. Next.
Item 3.
Premature release report flags the matter.
Single appellant.
Minor. Single appellant.
Dr. Gowda.
Appearing for the appellant on behalf of Mr. Manoj Mahajan.
Dr. Gowda.
Manoj, time may be granted to contact the appellant.
और पूछ लेके जाना
और the review the premature release report at flag D in view of the report furnished since the government has been pleased to remit the unexpired portion of the sentence passed on the appellant, and ordered for his premature release. This criminal appeal is disposed of. For a usual possibility, any application files on so. Yes, next.
Item 4.
Item 4, my lord, two appellants.
Hmm?
Two appellants, my lord.
Two appellants faced trial
Test trial,
and both of them were found guilty.
my lord.
अच्छा बिजनेस पिटिशन ଦି ଜଣ ପାଇଁ ଆସିଥିଲା ହଁ ଠିକ କଣ ମାନା କଣ ଗୋଟେ ଆଉ ଗୋଟେ ସମ୍ବାରୀ ମୁଣ୍ଡା
Somebody Munda and Mana Munda.
ମାନା ମୁଣ୍ଡା କଣ ହେଲା ସେମାନଙ୍କର
Number-
ଫେଲ ହେଇଯାଇଥିଲା
Somebody Munda died since 4 years due to illness.
କେଉଁ
And Mana Munda is alive.
ହେଲା କି ଦେଖନ୍ତୁ the Learning Council for the state has produced the written instruction dated 1/12/2023 of IIC Nayarpur Police Station, Mackenzie, which shows that appellant number 1, Sambari Munda, died since 4 years back, and appellant number 2, Mana Munda, is alive. The report is taken on record. Mr. Sahu, you have received the paper book.
Oh, my lord.
You have received
My
the
lord.
paper book. Learning Council for the appellant, Mr. Sahu submits that he is yet to receive the paper book. Let a copy of the paper book be supplied to him during course of the day, and matter will be listed next week for hearing. अच्छा एटा को लिखी देना ना sorry so far as this appellant number 1 is concerned, since no application has been filed है ना
By
by the
the
near
near
relatives so and so to continue the appeal abates so far as appellant number 1 Sambari Munda is concerned. So this appeal is now survives only for appellant number Mana Munda, clearly. And this is to be taken up next week, means you give the date, that is on 9th of December 2025 for hearing. Yes,
Item 5.
There are two appellants. But the report shows that he submitted the report to one appellant.
Govinda Munda and Mata Munda.
Mata Munda.
They faced trial under section 30307, and both of them were found guilty.
My lord.
Life imprisonment, both. And this prisoner's petition is for both. Mata Munda Jono fine Govinda Munda nahi di jana paye. ठीक है sir. So, कौन report आयला?
yes, I mean,
The report submitted by Govinda Munda.
Govinda Munda सरपंच है जैसे Govinda Munda मर जाइए.
My lord.
What about the Arata? नहीं आनी नांती.
My
ऐसा आनंद तो था.
lord.
Left from the पहले appellant number 1 हला बंची ये मर जाइए. Left from the Learning Council for the state has produced the written report of IIC Bamaberry Police Station dated 15/5/2025, which shows that the appellant number 1, Govinda Munda, is dead. He has annexed some documents.
with regard to the birth and death.
The IIC has annexed some documents in connection with the registration of death of the
Govinda
dead
Munda.
appellant, Govinda Munda. The documents filed by the Land Council for the state are taken on record. He seeks some more time to obtain instruction in respect of appellant number 2. कौन सा ना? Appellant number 2, Mata Munda. आर सप्ताह रख दो जो सही पुलिस स्टेशन में तो आसो.
My lord.
ये बात है बापू को अब बापू मर जाइए अब इटा पूरा जना कर ले. और आर सप्ताह रख this matter on 9th
Possibly valid.
हाँ
Possibly valid second half.
नहीं नहीं बापू आनो तो आ रहा है ना 9th of December 2020.
Item
अच्छा
6.
এইটা আপডেট করে দেবো
Govinda Munda.
আইটেম নাম্বার 1টা
Govinda Munda.
হলো
Item 6.
ସରି ବେଲେ ଆଇଟମ 2 ହଁ 2 ଟିକେ ଅପେକ୍ଷା କରନ୍ତୁ ଆପଣ ଏତେ ଦିନ ପରେ ଆସୁଛନ୍ତି ଆମକୁ ଆମେ ଯୋଗେଇ ଦେବୁ ଠିକ ଅଛି ୟେସ୍ ଆଇଟମ ନମ୍ବର 6 ଦିଅନ୍ତୁ Cola Plants.
Minus. Solar plan.
Acha, the Land Council for the state has produced written instructions received from dated for the 11/5/2025 from IIC Orchid Police Station, which shows that the appellant is alive. That is three load, na? The report is taken on record. With counsel here. B. Naik, PR Sahu S. Samal. ଜାଣିଛନ୍ତି କିଏ ମିଷ୍ଟର ନାୟକ ଚିହ୍ନିଛନ୍ତି କିଏ ବି ନାୟକ ବି ସାହୁ ଏସ୍ ସାମଲ ବିଶ୍ୱଜିତ ନାୟକ ଲେଖା ହେଇଛି ବିଶ୍ୱଜିତ ନାୟକ ବି ଆର୍ ସାହୁ ଜାଣିଛନ୍ତି ଖବର ଦିଅନ୍ତୁ ତାଙ୍କୁ ଲିଗାଲ ଏଡ୍ ବ୍ରିଫ ଆସୁନାହାନ୍ତି पेपर बुक भी रेडी है ଆପଣ ରିସିଭ କରିଛନ୍ତି पेपर बुक अच्छा ଏତିକି ଲେଖି ପାସ୍ ଓଭର करता हूं ହେଲା नेक्स्ट
Item 8.
Meet at flag B. Flag B, the premature release on 2011
ସେଗୁରା ଆଗରୁ ଗୋଟେ କଣ ଜେଲ କ୍ରିମିନାଲ ଆପିଲ ଫାଇଲ କରିଥିଲା 116/2018 ସେଟା डिस्पोज ऑफ ହେଇଯାଇଛି ତାର ଅର୍ଡର କଣ ହେଇଛି appellant has already prepared a criminal appeal sworn so against ଏଇଥିପାଇଁ ସେଟା ଯେହେତୁ criminal appeal ଫାଇଲ ହେଇଛି ବର୍ତ୍ତମାନ premature release report ଆସିଲା ଅଛି ଦେଖନ୍ତୁ CRLN number 395 of 2019 the
Address to registered himself by
the senior superintendent circle jail the
Katak Chaudhar.
At Chaudhar has written to has issued a letter dated 25/11/2025 addressed to registered judicial of this court wherein it is mentioned that the appellant Karunakar Panda has been released prematurely from jail custody on 20/11/2025 under premature rule. Relevant documents in that connection of the relevant orders of the government of Odisha Law Department in that connection has been annexed to the said report. In view of such report, the criminal appeal is disposed of after a application forms. Yes, so what are these content matters?
content matters. We may allow some time to take instruction.
This is coming for the first time.
Yes, my lord.
This
Order by one.
the content petition has been filed by the petitioner for non-compliance of the order dated 24/9/2024 passed in WPC number 22947 of 2020. in the operative portion of the order, we have observed as follows. In view of the above, there is no other impediment say porjanto lekhidedo hala. The grounds have been taken in the content petition that after obtaining the certified copy of the said order, it was submitted before the opposite party number 3 on such and such day, jaha lekha hai paragraph 3 re lekhibe hai na, and it is further stated that even though the time stipulated by this court has already expired, the contemners are not taking any step to comply the order of this court. Stop. Land counsel for the state seeks some time to obtain instruction in the matter. List this matter. ताकू रखुचु 2 सप्ताह हेले आपनकर आजि होउची 2 16 तारिख रखिदो हला डिसेंबर कैलेंडर एपटे 16th December 2025 instruction be obtained by the land council for the state in the meantime सबुडा के सेही टाइप रो हां 16 12 2025 तो 9 10 11 12 13 15 16 17 18 19 20 21 पर्यंत समान हो नेक्स्ट 22 टा डाकुन
Item 22.
यस मिस्टर बेहरा ये देखो तो चाली डिस्प्ले बोर्ड रे एटा कंप्लायंस एफिडेविट अपन को थिला सिटीजन सिस्टम मोर टाइम टू ऑब्टेन
ये इंस्ट्रक्शन ना
instruction नहीं पता
अच्छा एटा 500 और करथम तापर नेक्स्ट टा डाकुन
Item 23.
Copy of the representation postal tracking report has been annexed. And council submit the inspector of the receipt of the certified copy along with the representation. Not received any communication. On the 23 application. How time दरकार? अच्छा हो पहले तो 16 तारीख को रखो तो आनंद हो ना the land and council for the state तो कितने प्रॉब्लम है अगर 15 और 16 अपन चाहो ना दे 18 अछन दे अपन अच्छा land council हां 18 और 15 नहीं 15 तो मंगलवार और गुरुवार होची तो उसमें seek some more time to obtain the status of the representation as per the order dated 11/11/25. List this matter on 18th of December 25. Now that one, passport that one. ଅଧାଅଡ ଡକା ହେଇଥିଲା ନା ହଁ ୱାନ୍ ଟା କଣ ପାଇଁ ଡକା ହେଇଥିଲା ଅଧାଅଡ
no we had to give it to start with there.
अच्छा he is there अच्छा what about Mr. Mahanti please come we'll take up what is your matter that is your item number 2 item हाँ ये आसीगला आपनकर appellant जे वर्तमान जीवित अछंती तो आपन को आर्गुमेंट करिया पड़िबो आउ पेपर बुक अपन तो नहीं जाइथिबे पेपर बुक नहीं नाहंती पहिले नि से घर नहीं दे दे आस्तांदे मु जानि नाही आज रिसीव करंतु आप कितना आज रिसीव हला Mr. Srinivas Mahanti and counsel for the appellant is present submits that he has not received the paperwork. Let the paperwork be supplied to him during course of the day. He requests this matter to be taken up next week. Upon with item number 2. State council has submitted that he has received the paperwork. 9 तारीख रखुछु है ना? Next 9th of December 2025 for hearing ratios. ये paperwork टा देखिए 9/12/2025. Item number 1 for outcome sheet.
Ready okay, I should say.
1 for the council.
He is there. Yes. Huh? Item number 1
ପାଠାଟ ଥିଲା କି ଆଉ
ମନ୍ଦାକିନୀ
ପାଠାଟ ସରିଯାଉ ସେଇଟା ସରିଯାଉ ତାକୁ ପାଠାଟା କୋଉଟା ଗୋଟେ ଥିଲା
item number
24 ଟା ମନ୍ଦାକିନୀ ପଣ୍ଡା କୁଆଡେ ଗଲେ
ଫୋନ କରି ମାନେ ଚାଲିକି ଆସୁ ଲିଫ୍ଟଟା ପଳେଇଥିଲା ଚାଲିକି
ଆଚ୍ଛା ହଉ ଆଉ ଗୋଟେ କୋଉଟା ଥିଲା
ଦିଲ୍ଲୀପ
88
କେମିତି ଗଲା
ପାଠାଟା ତମ ପାଠାଟ ଗୋଟେ
ପାଠାଟା
ହିୟରିଂ
ଉପରେ
କରିଦଉ
ରହିଗଲା
you make a ଇଏରେ ଯେଟା ପାଠାଟ ମ୍ୟାଟର୍ସ ବୋଲି
ପାଠାଟା 88 କେମିତି ଯିବ
ତା ନମ୍ବର ଅନୁଯାୟୀ ତମେ once you give a କମ୍ପ୍ୟୁଟର ନେଇଯାଉଛି ଠିକ ଅଛି ବଟ୍
ପାଠାଟା
once you make a separate heading ସେ ଅଟୋମେଟିକାଲି ପଳେଇ ଆସିବ ନା ତା ଭିତରକୁ ସେ ଦିଲ୍ଲୀପ ରୟ କରୁଥିଲେ ତାଙ୍କୁ ଟିକେ ଖବର ଦିଅନ୍ତୁ
ହଁ ଛଅଟା ବି
ଛଅଟା ପାସୱାର୍ଡ ଦେଇଥିଲା କଣ ପାଇଁ ଓ ଯୋଉ ଜଣେଇବା ପାଇଁ ବିଶ୍ୱଜିତ ନାୟକଙ୍କୁ ଜଣେଇଲେ ଫୋନ କଲେ ବସନ୍ତ ମ୍ୟାଡାମ ବସନ୍ତ ବିଶ୍ୱଜିତ ନାୟକଙ୍କୁ ଜଣେଇଲେ
already telephone Mr. Sajnagali interpreted. He is 22 compliance update ଦେଇଥିଲୁ ସେ କହିଲା instruction ନେବା ପାଇଁ କହିଥିଲୁ No, let's see. Mentioned here that there are 3 eyewitnesses to give. Lordship, there are 3 eyewitnesses. Two eyewitnesses already hostile, and one 18 and 19. 6, 9, 8, 9 eyewitness 9. 6, 18, 9, 18, 19. 18, 19. No, 6, 18. Lordship. So according to you, 18 and 19 have not talked of it. Lordship, hostile. They are hostile. Lordship. And 6 is the Lordship disbelieve the learning bill. 6 disbelieve this. The statement. Learning trial court. Which Lordship. on the basis of oral dying declaration before PW7, PW1, PW3 and PW4 and Lordship. ନା ଲର୍ଡସିପ ସେଟା ଜଜମେଣ୍ଟ ରେ ତାଙ୍କ ସେଇଟା ଯୋଉ ଡାଇଂ ଡିକ୍ଲାରେସନ ଟା ଦିଆ ହେଇଛି ତାଙ୍କ ନେମ୍ ଟା ସେଇଟା ସେ ନେଇ ନାହାନ୍ତି ତା ଦେହରେ।
It is correct that out of these three eyewitnesses, 18 and 19 have been declared hostile by prosecution. So far as PW6, the only eyewitness according to her, who has been also disputed by the trial. Is correct? What is the answer? According to paragraph 7 of the trial for the defense, is only page is 16. And there in that page the last 4 lines. But also the I was like that. Page number 16, paragraph 7, trial for this.
But unfortunately, we do 18 and 19.
Madam,
Lordship.
Suma number to start.
Lordship, yes.
Clerical line, four lines only part. But unfortunately, paragraph 7.
Paragraph 7.
Paragraph 11 of page 16.
Again, Lordship.
Now the last 4 sentences.
Thus, from the above evidence of the homecoming school children PW 18 and 19 and that of PW 7 appear to be more relevant for the purpose of the case, but unfortunately PW 18 and 19 have turned hostile to the prosecution, though they were the star witnesses for the prosecution. On scrutiny of their evidence, it appears that when PW18 claims to have no knowledge about the occurrence, PW19 had admitted during cross-examination by prosecution that at the relevant time himself and PW18 were returning from the school in a cycle. But so far as the incident is concerned, like PW18, this PW19 has also stated to have no knowledge about the occurrence. As I gather, these witnesses are not at all truthful to their version. Rather, they are found suppressing the real fact. Not so. Sure.
Evidence of PW6 indicates.
This evidence of PW6 indicates that by the time he passed through the spot, he had noticed the PW7 and the doctor with whom he was coming as claimed by PW7. The further evidence of PW6 indicates that after seeing the deceased lying injured, he had rushed to intimate the other villagers along with PW7. From the evidence of PW1, the wife PW2, the cousin brother, PW4, the son of the deceased, and PW3, an independent villager, it appears that they had got the information from prosecution witness 6 and 7 and also from one Suresh Majhi. Therefore, the evidence of PW7 that he had reached the spot soon after the occurrence cannot be disbelieved. It is the human tendency of every villager to rush to the scene of occurrence. No sooner they get the information of an incident. Likewise, the witnesses like PW1 to 6 and 6, 8, and 11 have deposed to have had rushed to the spot soon after the occurrence by getting information from PW7 and other villagers.
That he, after getting information from PW7, he also therefore he cannot be said to be an eyewitness. So, but specifically, since she is lying there, but he through Jona Pucci is so if these three eyewitnesses are not there, then on the other day you stated that there is 12-time declaration before number of witnesses who reached the scene of crime and found that the deceased was alive, and before then the deceased is good. So, like PW1,
3, 4, 4, 7. Let's say 5 terms going nahi tadre. Khali 7, 1, 3, 4.
sure.
अब ना सात 16 हाँ डॉक्टर हाँ हाँ
So let us come to one eyewitness and declaration number
Lots.
why
Deceased. Lots.
Please come to the evidence or evidence at page number 40.
But I know both.
Mr. Behra, why is this content procedure?
I was the election court number 12, Lord, sorry, Yes. Yes, Lord, sir.
You have already attended.
I instructed today, Your Lordship. There is 18 case, so motor refer, Your Lordship. That complaints affidavit देना दिसे जो रिपोर्ट टा देखनी मो पाखरे अछि Your Lordship. ठीक गोटे रिपोर्ट देखनी रिपोर्ट रे लिखन जे गोटे एलआर केस फाइल हेतला माने
Item number 22 wrong.
complaints affidavit not filed.
Section 1.
My lord.
The operative part of the letter is the submission made and without expressing any opinion on the merits of the case, this court disposes the petition directing the opposite party number 3 to dispose of negative sponsor and appearance of law. It is without 3 months from the date of production of the directive.
My lord.
What is the status? We just want that that was the direction, whether it has been complied. Baki so we are not concerned.
Yes, sir.
It is further directed that in case the application from the petitioner is allowed, and there is no legal, no other legal impediment, the compensation amounts are disbursed in favor of.
That was the application under section 28A, Your Lordship. 28A of the Land Action Act. There now they have supplied the information that the earlier the petition, the LR case was referred, LAR, under section 18, Your Lordship, which was disposed of. Thereafter, CMA application also filed, that was disposed of. On that score, I have taken the instruction to that the same as the disposed of, Your Lordship.
We are disclosing of this.
Directly disposed of my application.
Content of the game. The match was taken off. Six 11/24. Land Council for the state produced the written instruction dated of AC laws to the other pursuits. Of special legal and RRO Europe in the irrigation project area. And the same was taken on record and a copy of this same was handed over to the Land Council for the state. This was the Land Council for the petition. Who sought for time to obtain instruction. And the matter was further listed on 11/11/2025 and 18/11/2025. Now the prayer made by the Land Council, the matter was adjourned. We should be our Land Council of the petitioners submitted that he has taken instruction in the matter. And, since what are the instruction formally?
That is the LR separate proceeding which was disposed of.
That the proceeding has already been
Dropped, dismissed. LR proceeding. Under section 18.
Already been dropped.
Dropped.
In view of such submission made by the Land Council for the petition, the content proceeding is closed. Yes, next.
এটা ସେପାରେଟ ପ୍ରୋସିଡିଂ ଆପ୍ଲିକେସନ ଟା ପେଣ୍ଡିଂ ରହିଛି ତାଙ୍କ ପରେ ଡିସ୍ପୋଜ କରିବା ପାଇଁ 28 ଆପ୍ଲିକେସନ ଟା ଏଇଟା ବର୍ତ୍ତମାନ ଯୋଉ କଣ୍ଟେମ୍ପ୍ଟ ଆରାଇଜିଂ ଆଉଟ୍ ଅଫ୍ ଆନ୍ ଆପ୍ଲିକେସନ filed by the petitioner under section 28A of the Land Action Act. ସେଇଟା ପେଣ୍ଡିଂ ଅଛି ସେଟା ଡିସ୍ପୋଜ ପାଇଁ ଡାଇରେକ୍ସନ ଯାଇଥିଲା ନା ନା ସେଟା ଡିସ୍ପୋଜ ହେଇସାରିଛି ନା ସେଇଟା ବା ଦେଲେ ରିଫଣ୍ଡ ମୁଁ ପାଇଁ ସେକ୍ସନ ଆଣିଲି ଆଜ୍ଞା ଡିସ୍ପୋଜ ଡ୍ରପ୍ ଡିସମିସ୍ ହେଇଯାଇଛି since 2006 18 ଟା 18 ଟା so moto reference by the land action collector without the knowledge of the petitioner. When we received the initially compensation with the objection, thereafter the matter was referred by the land action collector to the Warrant Civil Court. LR case ଗୋଟେ number ହେଇକି ସେଟା non apparently dismiss ହେଇଯାଇଛି in 2013. But the 28 application filed by the petitioner in the year 2020.
LR dismiss ହେଲା ପରେ ସେ CMA ଫାଇଲ କରିଛନ୍ତି.
CMA also dismissed.
CMA 8/19
8/19 also dismissed.
Thereafter, the CMA application was filed.
8/19.
It was also dismissed.
Yes, sir.
So, in view of such state of affairs, as has been stated by the Land Council for this petition, there can be no impediment
Yes, sir.
for
The application under section 28A
Thereafter, in the report last line, in the meantime, meanwhile, Madhubag Raghubag has filed a 28A application for the same khata.
ସେଇ କଥା କହୁଛି ମୁଁ ଆଉ କଣ କହୁଛି
Therefore, there will be no impediment for disposal of a application filed by the petitioner under section 28A of the LAR 1894 as was directed in the order dated 13/1/2035. And the land council for the state is pending before whom?
Before the special land auction officer
Which is stated pending before the which is the opposite party contempt.
opposite party number 3 contempt law.
Opposite party. You read it down there.
Read it.
Okay. It's not before the opposite party number 3. The definitions that is special land acquisition officer or where the application the obviously order be handed over to the land council for the state, we should be forwarded the opposite party number 3 who shall comply the order. Within a month or two. Now there is no impediment we have mentioned because that LAR comes, then CMA and of course that part also states there that if we out the then that is yes, net.
Oblige your lordship.
Lordship, can we see the PW1, Lordship? And
See the video of the deceased
Lordship,
and see the witness to the time.
I know both the accused person who were standing in the dock. The occurrence took place a year before last in the month of Magha in the afternoon. I was in my house when Lordship, अब हाँ appellant allegation report. I was in my house when Suresh came and informed me that my husband Shivnath was assaulted, and he also informed me that Dhado, accused Ravindra Kalo, and accused Sundarmani Kalo identified caused injuries on my husband Shivnath on the way while he was returning from the school. Lordship? PW1? Suresh Maji is not examined. धड़ ब्रैकेट रे होची रविंद्र कालो रविंद्र कालो and accused Sundarmani Kalo identified caused injuries on my husband Shivnath on the way while he was returning from the school. I went to the place where my husband was lying and gave water to him. My husband was able to talk at that time, and he told me that accused Sundarmani Kalo and Ravindra Kalo caused injuries on his person by means of lathi and tangia. I, along with others, brought my husband to DHO hospital, Sundargarh, for treatment. The doctor, after examination, declared my husband to be dead. I had already reported about this incident at the PS by the time my husband was brought to the hospital. Cross-examination. One Suresh Maji informed me while I was in my house about this incident. I cannot say the exact time when he gave me such information. He informed me about this incident in the afternoon in between 5 to 6 p.m. First, I went alone to the spot and gave water to my husband, and thereafter others members of my family and villagers came to the spot. I had prepared tea for my husband before I got information about this incident. Usually, I prepared tea for my husband every day. In the afternoon, my husband was lying at a place which is at a distance of about 1 kilometer from our house. By the time I arrived at the spot, many persons had assembled there. We brought the deceased from the spot to our house in a cart, and from there we brought him in a cart, and on the way we brought him in a trekker to the DHO hospital. I examined by I was examined by police during investigation of this case. It is a fact that I stated before the IO that not examined that Suresh Maji, Pruset Dandasena, and Rangi Pathan, that Rafik Pathan, came to my house and informed me that my husband was assaulted and that he was lying on the road near Gurubudia bridge. It is not a fact that I had not been given water to my husband and that my husband was not in a sense by the time I reached there. It is not a fact that I had not asked anything to my husband and that he had not told me the name of his assailant. It is not a fact that I am deposing falsehood.
Statement of the ego of the deceased is also supported by the other persons like Peter 3, 4, and 7. Where
Present there.
And they have
Five also. Five also.
फाइव सेपरेट थिंग्स फाइव कହୁଛି କେହି ଯାଇନଥିଲେ ମୁଁ ଯାଇଛି ସେଇଟା ସେପାରେଟ ଥିଙ୍ଗସ୍
that when the deceased was asked about the assailant, he told that who the occurrence has assaulted his and by this way.
सर से तांको आगे खाली कोन अलगा विलेजर्स भी सेठी ଥିଲେ ତାପରେ 1 ନମ୍ବର କହୁଛି I went to alone କିନ୍ତୁ PW4 କହୁଛି I along with my mother.
That is not important. After what she says that when I arrived there, at that spot, many persons had already assembled. The deceased was asked by some persons, including his wife, and obviously he has narrated the incident. The question is that he has not stated in a different manner. That no, ଜଣଙ୍କ ପାଖରେ କହିଥାନ୍ତା ମତେ X ମାରିଛି ଆଉ ଜଣଙ୍କ ପାଖରେ କହିଥାନ୍ତା Y ମୋତେ ମାରିଛି. That's a different because all the witnesses have implicated stated that the name of the assailant which has been ordered by the deceased was these two occurrences. Also the yeah. So why gives the evidence of all the witnesses relating to quarantine declaration? Because by the time I appears, the deceased reached the hospital was declared dead. Well, right? मैं आपको एक क्वेश्चन ये quarantine declarations कितने लोगों को होता है, including not only the family members but also the I think co-villagers have also stated.
Cousin brother.
But there is no such relationship. He just a co-villager. Team number, co-villager. He stated that he gave water to so-and-so, asked him about his assailant, and so-and-so disclosed that he may cause injuries on his person by assaulting him. And number that was son of the deceased. So then What about your number 7? Number 7. He's an independent business to be a station. I saw the deceased was lying, having some sustained bleeding injuries on his head, and the doctor who had gone to see my mother asked Sri Sivanath Taluk, the deceased, about this incident, and deceased disclosed that both the accused persons assaulted him, caused him injury on his person. So unless you bring something on record, because apart from possible witnesses who are related to the deceased, as wife, son, and cousin, brother, or something like that, PW2, there are two independent witnesses who are the co-witnesses. So they have also stated the same thing, that the appellant disclosed before them that it was the two appellants who assaulted him, and ultimately he was taken to the hospital with therapy. What has been brought in the cross examination? Why is the evidence to be unless you bring that the deceased was not in such a condition to make any time declaration, his health condition or his mental condition was not that okay, and his evidence is inconsistent, or otherwise it was such a time he could not have noticed the assailants, and he has falsely stated by making assumption or like that. What is there in the dynamic declaration of this citizen?
Lordship,
So many persons.
Lordship, PW1 cross examination 1.4 ସେ ତା ଦେହରେ ଯୋଉ କହିଛି ଯେ ସୁରେଶ ମାଝୀ ଆଉ କ୍ରୁସେଟ ଦଣ୍ଡସେଣା ରାଫିକ ପଠାନ ଆସିକିରି ଇନଫର୍ମ କଲେ, କିନ୍ତୁ ରାଫିକ ପଠାନ କହୁଛି ତାର ୱିଟନେସ୍ ଯୋଉ PW5 କହୁଛି ଯେ ମୁଁ କ୍ରୁସେଟ ଦଣ୍ଡସେଣାକୁ ପଠେଇଥିଲି, ଆଣ୍ଡ କ୍ରୁସେଟ ଦଣ୍ଡସେଣା କହୁଛି ଯେ ମତେ ମୁଁ ଯୋଉ ଡକ୍ଟରକୁ ଡାକିବାକୁ ଯାଇଥିଲି ମତେ ସେ ମାନେ ପଠେଇଲେ ଇନଫର୍ମ କରିବା ପାଇଁ। ତେଣୁ ଏ ଦି ଜଣଙ୍କ ଭିତରେ ତାହେଲେ ଆଗ କିଏ ସେଠିକି ଯାଇଥିଲା, ଆଗ କିଏ ତାଙ୍କର ଘରେ ଇନଫର୍ମ କରିଛନ୍ତି ସେଇଟା ଜାଣିନାହିଁ।
Message has reached the family members that they have come, and somebody might have reached earlier because the distance they have stated it is 1 kilometer from there. That is not very material. Thing is that all of them have stated that the deceased was asked about the name of the assailant, and he disclosed that these two appellants are the assailants.
And deceased had a severe head injury, and how he was mental fit,
For that, you should have thought something.
State of mind,
Doctor, and if a person received type of injury, his death would be instantaneous. Doctor, go back to the doctor. This is wrong.
Head injury
16 minutes.
16, and he was
He has opined that the cause of death was due to leading to coma due to injury matter of
and that is the severe injury, Lordship, head injury, and how he was fit, state of mind.
We are not the expert. We just asking that he has conducted postmortem examination. He has seen what is the external injury, what is the impact, also visualized. So if we could have elicited something from the evidence of the doctor, that doctor, you see that if a person receive such injuries and internal injuries, his mind would not be like
May
that.
not be in the conscious state, he could not have spoken.
Coherent statement could not have, or that କିଛି ବି ତ କିଛି ଗୋଟେ ବାହାର କରିଥାନ୍ତେ ନା। ଆମେ ବର୍ତ୍ତମାନ କେମିତି assume କରିଦବୁ ଯେ କାରଣ ଆପଣ କିଛି ଆଣିଲେନି ଯେ ନାଇଁ ଡିସିଜ ର ସେ ପହଞ୍ଚିଲା ବେଳକୁ ଏମାନେ ତାର ଡେଥ୍ ହେଇଯାଇଥିଲା।
କିନ୍ତୁ PW6 ଟା ବି କହିଛି ଯେ on the way he dead,
on the way is not relevant. At the spot, see on the way रे कई कहूनाहांती dying declaration ହେଇଛି ବୋଲି ସମସ୍ତେ କହୁଛନ୍ତି
On the
dying
spot.
declaration
Due to
ଯୋଉ
spot.
spot ରେ ସେ ମାଡ ଖାଇ ପଡିଥିଲା ସେଇଠି ଯେତେବେଳେ ପହଞ୍ଚିଲେ ସେଇଠି ହିଁ dying
ପଚାରିବା।
declaration ତାପରେ ତାକୁ ହସ୍ପିଟାଲ କୁ ନେଲା ବେଳେ ବାଟରେ ମରିଯାଇଛି ultimately declaration ହେଇଛି by the doctor that he is dead ତେଣୁ ହଁ ଆପଣ ଯଦି spot ରେ କିଛି ନ କହିଥାନ୍ତେ on the way ହେଇଥାନ୍ତା this matter is different now spot ରେ ଯେତେବେଳେ ଏତେ ଗୁଡେ ସାକ୍ଷୀ କହୁଛନ୍ତି ଏବଂ ଡକ୍ଟର କୁ କିଛି ଆଣି ନାହାନ୍ତି ଆପଣ now you say that because he has sustained the head injury he could not have been in a position to say that how can we assume all these things
Middle one gave water to him. Middle one gave water to him.
ନା ସେଟା ତ ଇଏ ବି କହିଛି ରାଫି ବି କହିଛି
ଆଉ ଗୋଟେ କି
ରାଫିକ ବି କହିଛି ମୁଁ ଦେଲି ବୋଲି
ପାଣି
ମୁଁ ଆଗେ ପହଞ୍ଚିଲି ତାକୁ ପାଣି ଦେଲି ବୋଲି କହୁଛି I had seen caught
and
injuries by trachea.
they have stated that he stated my husband was able to talk
Yes, sir.
at the time ତାପରେ ତାର ଯୋଉ ଇଏଟା ମଧ୍ୟ କହୁଛି I asked my brother so and so and he told me ତାପରେ ସେ ଯୋଉ ତାର ଗୋଟେ ପୁଅଟା ଯୋଉ ଅଛି ଏବେ 4 ନମ୍ବର ସାକ୍ଷୀ
ନାଇଁ,
That
Son of
ସେ ବି କହିଛି, ହଁ।
I went to the place I seen pot injury
Yes, sir.
I asked my father regarding this he told me that's one
So it is all consistent for
we have consistently
But lordship, medical evidence showing that he is not able to.
Kind-
treat him.
Where is that?
I'm just here ଚାହୁଁଛୁ ଯେ ଦେଖାନ୍ତୁ ଆମେ at least we want to know that from where you got that impression that he sustained that head injury but he could not have been able to speak
You have simply, it has been brought that 5 strokes are necessary for causing 5 external injuries found by me. External injury number 5 may be caused by fall or dash. External injury number 1 to 4 are possible by sharp cutting weapon. And so it is all about that, how it could have happened.
oral dying declaration ଯୋଉଠି ରହିଛି ସେଠି postmortem doctor ର cross examination ର ବହୁତ importance ରହିଛି କାରଣ ସେଇଟାକୁ ଜଣେ defense counsel ଆଖି ଆଗରେ ରଖିବା କଥା ଯଦି ମୁଁ ଏତିକି କିଛି material ଆଣିପାରେ ଯେ ଏଭଳି blow ପାଇକିନି ଏଭଳି internal injury ହେଇକିନି ତାର condition ଇଏ ନଥିବ referring to some jurisprudence ମୋଦି ହଉ ଟ୍ରେଲର ହଉ ଅନ୍ୟାନ୍ୟ ଦେଖେଇକିନି କିଛି ଆଣିଥିଲେ ହେଇଥାନ୍ତା ବଟ୍ କିଛି ଆପଣ ଆଣିନାହାନ୍ତି ଖାଲି
ତାପରେ 27 କୁ ପୁଣି କିଏ ସପୋର୍ଟ କରୁଛି ଲିଡିଂ ଟୁ ଡିସ୍କଭରି କୁ
Middle 9 and 10.
9 and 10 କହିଛନ୍ତି 9
ଏ ଯୋଉ ରିକଭରି ହେଇଛି ଯୋଉ ଟାଙ୍ଗିଆଟା PW9 ଆଉ PW10
9 ମନା କରୁଛି nothing was system
9 ହୋଟଷ୍ଟାଇଲ ହେଲା 10 ସପୋର୍ଟ କଲା ନା ହୋଟଷ୍ଟାଇଲ ହେଲା
10 hotel.
ଦି ଜଣ
ତାହେଲେ ଖାଲି
ପ୍ରାଇଭେଟ ୱିଟନେସ୍
ପ୍ରାଇଭେଟ ୱିଟନେସ୍ ହୋଟଷ୍ଟାଇଲ ତାହେଲେ ଖାଲି ଆୟୁ
ଆୟୁ
ଯାହା
ଟା।
କହିଛି ଆୟୁ କେତେ ନମ୍ବର ସାକ୍ଷୀ
21.
PW21 ସେ କହିଲା ରିକଭରି ବିଷୟରେ ଟାଙ୍ଗିଆର
କାଇଁ
from the house of this Sundarmani Kalu
cease to undertake
କୋଉ paragraph ଟା ଦେଖେଇଲା
I post it is on that was directed by the representation for appropriate to village one of your examined witnesses. And see what
20 is the
No, no, sir, lordship 20.
20 is the
20 is it.
20 नंबर 21 में
No.
इज द आईओ
Right.
नहीं जो वेपन लीडिंग टू डिस्कवरी सेटा कोउ पैराग्राफ रे अछि अपलाइन नंबर 1 रो इंस्टेंस रे ये जोटा मिलिला आपनकर टांगियाटा रिकवरी हला सेटा कोउ पैराग्राफ रे अछि
Paragraph 4.
4 mile.
अच्छा पैराग्राफ 4
Thereafter, the accused Sundaramani Kallo led me and witnesses to his house and gave discovery of a
Budia.
Budia.
Acts of MO1.
The accused told me that he threw away the handle in the jungle, but the same could not be traced after the search.
Para 5, on the same day, the accused Sundarmani Kalo also gave discovery of lathi from inside jungle near the spot. MO2 is the said lathi. Executive is the seizure list, and executive 12(1) is my signature, and executive 12/2 and executive.
Mr. Pradhan, if we come to the dying declaration, which has been made before this PW1, who is the widow, about this weapon used by the two appellants. In the dying declaration, it is stated that who has used which weapon. And the ଜଣେ ତା ଦେହରୁ PW2 ର evidence rather ଟିକେ clear ଅଛି.
ଜଣେ ଟାଙ୍ଗିଆ ଜଣେ ଲାଠି ଯୋଉଟା କହିଲା.
ଜଣେ ରବୀନ୍ଦ୍ର କାଲୋ ଯିଏକି ହେଉଛି appellant number 2 come to PW2 ମାନେ କି ହେଉଛି ଭାଇ. Accused Rabindra Kalu caused injury to him by lathi. Our appellant number 1 Sundarmani caused injury on Budia and Tangia. ये जो डॉक्टर बाबू जनक हेले PW16 सी कहउछंती जो पांचटा इंजुरी मु देखिली 1 ରୁ 4 possible by sharp side of the axe. So obviously it is as per the dying declaration it would be attributable to appellant number 1 because he was using that Tangia, right? आउ बाकी जो गोटे इंजुरी रही गला सेटा होची कंट्यूजन टा जोटा की अछि लेफ्ट चीक ऑफ द फेस. डॉक्टर कहउछंती जे से इंजुरी टा इट कैन बी कॉज्ड बाय फॉल.
Could have been whether he was made to grounded at the time of the.
So what about this lathi blows? Panchtar who injury to lathi dwara hei paribo because those weapons were seized and weapons were not produced before this doctor who has conducted the postmortem examination for verification. But the doctor has stated that
the contusion of 5 centimeter in diameter over which there was a lacerated wound of size 1 centimeter by 1 centimeter. On polar evidence, yes. On the left side of the cheek of face.
But in the stated that it is possible by fall.
Could be possible by fall.
So cross examination. External injury possible by. But again, he has stated in that very cross examination, in external injury number 5 is sufficient to cause death.
Fall or dash. Could be.
So this injury is maybe lacerated wound माने 8 लाठी पर 8 possible बनो. अब बाकी ये जो 1 2 3 4 से बोल रहे हैं ये टाउ 7 कटिंग अपन माने से जो टा धरला बुढ़िया टांगी
1 2 3 4 7 कटिंग
हां
1 2 3 4 7
हां 7 कटिंग ये जो 5 नंबर का वो और लाठी course, in that Ars and Lati, as per the C report, no blood was found. That is page 103, C report.
The Prax is concerned no blood.
Lati page number, you come to page number 103. Actually, no blood. Lati re blood achi, but
Yes.
no origin re no opinion achi, grouping be no opinion.
Deteriorated.
So, if we see the case in that eyewitnesses, let us say that no importance has been attached to them by the London trial court, and 18, 19 clearly not supported. 6 has been held to be a post-occurrence witnesses because by the he got the message and came to the spot. Obviously, by that time the occurrence is already over, the assault part is over. But this oral time declaration and specific role attributed regarding that who was holding which weapon, and it is coupled with that evidence of the doctor PW16 who has noticed 4 incised wound, 1 lacerated wound on the vital part of the body, which has led to the death. So why what is the motive behind the commission according to the prosecution? Anything brought out?
Previous enmity is there, Lordship.
Which-
Judgment ର ପାରା
କିଏ କୋଉ ସାକ୍ଷୀ କହିଛନ୍ତି ନା
ନାଇଁ ସାକ୍ଷୀ କହିନାହାନ୍ତି
ସାକ୍ଷୀ ତ ନା
Court knowledge.
କୋଉଟା ଟ୍ରାଏଲ କୋର୍ଟ କୋଉଠୁ ଆଣିଲେ?
ପାରା 14
Para 14. Let us see.
The document was seized.
Huh?
The document was seized.
What document?
Compromised documents were seized.
Which is the document? ତାଙ୍କ ଭିତରେ ଗୋଟେ ବିବାଦ ଥିଲା ଯୋଉଟା କଣ ଡକ୍ୟୁମେଣ୍ଟଟା କଣ କୋଉ ପ୍ରକାର ଡକ୍ୟୁମେଣ୍ଟ?
One purported to have two Panchanama.
ଆରେ ମାର୍କ ହେଇଯିବ ତ ଏକ୍ଜିବିଟ ହିସାବରେ ହେଇନି ଆଉ ଦେଖିବୁ
No, the prosecution has only filed 2 Panchanama. They actually MO 5 and 6. One purported to have been executed by Vishnu Kalo, the father of the accused, Sundaramani Kalo, and the other by Dhoba Kalo, the father of the accused, Ravindra Kalo. But though these letters of undertaking contain the signatures of various other villagers, the same have not been proved. Besides Lochan Kalo, from whose possession it was seized by the police, has remained silent about these papers. Therefore, no reliance
can be placed as seen.
Reliance can be. But, however, when in a case on the motive is not necessarily to be proved always. No, he has not.
So dying declaration को ଆପଣଙ୍କର challenge ହଉଛି ଯୋଉଟା କହୁଛନ୍ତି mainly that in view of the injuries sustained by the deceased, particularly on the head and its impact on the internally also, the deceased could not have been in a position to make dying declaration. ଆପଣ କଣ କହୁଛନ୍ତି? How many blows were given on the deceased? On the head?
Head faster.
ସବୁତକ ଇଞ୍ଜୁରି ଗୁଡାକ 5ଟା ଯାକ ଅଛି head ରେ. Inside wound, bone deep,
was present
left
left parietal.
1, 2, 3, 4.
1, 2, ସବୁ
3, 4, 5.
ସବୁଟା ସେଠି। Eta last one is over No, that is continuous. But all the inside injury was on the vital part.
Are on the head.
Over left occipital region, left ସବୁ।
ଆଉ ବାକି ଦେଖନ୍ତୁ internally ସେ କଣ କରିଛି ତାର effect କଣ ହେଇଛି internally there was clot mixed blood present in subdural space at left occipital region of the brain corresponding to the external injuries on head. The spleen was lacerated on the lower border in a zigzag manner and was associated with large quantity of liquid so and so. All the injuries were antemortem in nature. Same was sufficient in ordinary course of nature to cause death. Cause of death was due to hemorrhage and shock, leading to coma due to so and so. And to the vital organ like spleen and compression of brain. So if you say that the deceased has sustained these injuries, whether it was not the duty of the prosecution, even if somebody receives these injuries, you will be in a state of mind to speak perfectly, coherently. ପାଞ୍ଚଟା ଯାକ injury head injury ରହିଲା internally ସେଇ type ର ତାର effect ରହିଲା ତାକୁ coma ହେଇଯାଇଛି leading to coma then cause of death was hemorrhage and shock ତେଣୁ ଏଭଳି ମାଡ଼ ଖାଇଲା ପରେ ଏମାନେ ଯୋଉମାନେ ବି ଆସି ପହଞ୍ଚିଛନ୍ତି କିଛି ତ time gap ହେଇଥିବ let us say at least 10 minutes ଲାଗିଥିବ ଏମାନେ ଯାଇଥିବେ କାରଣ ଘରେ ଖବର ଦେଇଥିବେ 1 କିଲୋମିଟର ସେମାନେ
1 kilometer distance 1
1
kilometer
କିଲୋମିଟର ସେମାନେ ଆସିଥିବେ
by cycle
10 to 15 minutes ତ ଲାଗିଥିବ ନିହାତି
10 to 12
ସେଠି ସେ ପଡିକିନି ରହିଛି ତେଣୁ ସେ ତାର ଯାହା ବି ସେ କହୁଛି ତାର वन की अन्य विटनेस ଯାହା ବି ସେମାନେ ଶୁଣିଛନ୍ତି ଯେ ସେ ତାକୁ କହିଲେ ଯେ ଏଇ ଦୁଇ ଜଣ ମାରିଛନ୍ତି ସେଇଟା ସେ ଗୋଟେ perfect state of mind ଥିବ
ପରବର୍ତ୍ତୀ ଜଣକୁ ତାକୁ କହିବି ଦେଇପାରିବ ତାପରେ ଏଠି ନାହିଁ କେହି ଆଣିଛନ୍ତି state of mind, but you can say just before that, like you want to go.
its state of mind जो आनिबा दायित्वटा कहार ये टाइप रो केस है
Doctor, absent of the person.
Whether it is of the prosecution
or the defense. Suppose defense किसी पचारी नहीं about the state of mind to the doctor. But when we see, we are seeing that this man has received as many as 5 injuries on the head itself. And it has led to coma. Ultimately, he died and very soon. While shifting, he has died. By the time he reached the hospital, the death has occurred. ତେଣୁ ମାଡ଼ ଖାଇଲା ପରେ ଯାହା ବି ସେ ଷ୍ଟେଟମେଣ୍ଟ ଦେଇଛି let us say that କିଛି ସେ କହିଛି ସେଇ କହିବାଟା ମାନେ ବାଉଳି ଚାଉଳି ହେଇକିନି କହିଛି ନା ତାର ଷ୍ଟେଟ୍ ଅଫ ମାଇଣ୍ଡ ପରଫେକ୍ଟ ଅଛି ଏଇ ଟାଇପ ର ଇଞ୍ଜୁରି ପାଇଲା ପରେ ଯୋଉଟା କି କୋମାକୁ ଲିଡ୍ କରିଛି ସେଇ ଏଭିଡେନ୍ସ ଆଣିବାର କାହାର ଆଉ ସେ ତ ଆପଣ ଆଣିନାହାନ୍ତି it depends upon jurisprudence. It depends upon that somebody may survive also for 3 to 4 days. Even somebody may also revive after so many days. ଆଉ କିଛି ଲୋକଙ୍କର instantaneous ହେଇପାରେ. It depends upon that. Head injury ପାଇଲା ମାନେ ନୁହେଁ ଯେ ସମସ୍ତେ ଗୋଟେ କୋମାକୁ ପଳେଇବେ ବା ଇଏ କରିବେ. ତେଣୁ head injuries କିନ୍ତୁ ହେଇଛି. ଆଉ 5ଟା head injury ହେଇଛି. 4ଟା ତା ଦେହରୁ incised ଆଉ ଗୋଟେ lacerated.
On the same place there several injuries.
And occurrence time ଗୋଟେ କିନ୍ତୁ ଏମିତି ନୁହେଁ ଯୋଉ ସମୟରେ କି identification ର କିଛି problem ହବ.
Returning from the school. Returning from the school.
It was quite
ମାନେ
daytime.
Daytime.
Time 4ଟା-5ଟା ବେଳକୁ ଘଟଣା ହେଇଛି. ତେଣୁ
ଅନ୍ଧାର ନାହିଁ କି କିଛି ନାହିଁ.
ତେଣୁ identification ର କିଛି problem ନାହିଁ because they are all co-villagers. ତେଣୁ co-villagers ତ କାରଣ they are
ଅନ୍ଧାର ହେଇଥିବ କାରଣ ଏଟା ଯୋଉ ସେ ଲେଖିଛି ଯୋଉ PW1 କହିଛି ଯେ the occurrence took place a year before last in the month of ମାଘ ମାସେ ତ ଆମ ଶୀତ ଦିନେ ସନ୍ଧ୍ୟା ହେଇଯାଏ 5ଟା
4:30 ସମୟ ସନ୍ଧ୍ୟା ହେଇଯିବ.
4:35 returning from the school.
ସ୍କୁଲରୁ ଫେରୁଥିଲେ ପୁରା. ଆଜି ସ୍କୁଲକୁ ପାଠ ପଢିବା ପାଇଁ ଯାଇଥିଲେ. ଏଇ ସମୟରେ ଆମର ଗ୍ରାମ ଥିଲା. ସେ ମାଷ୍ଟର ଚାକିରି କରନ୍ତି ଶିବନାଥ ଏବଂ ସେ ଆଜି ସ୍କୁଲ ପାଠ ପଢିବା ପାଇଁ ଯାଉଥିଲେ. ତାପରେ ଘରେ ଆସି ଖବର ପହଞ୍ଚିଲା ଯେ ସିଏ ତାଙ୍କୁ ପୋଲ ପାଖରେ ମାରିକିନି ଫିଙ୍ଗି ଦିଆହେଇଛି. ଖବର ପାଇ ଘଟଣାସ୍ଥଳକୁ ଯାଇ ଦେଖନ୍ତି ଯେ ଶିବ ରାସ୍ତା କଡରେ ପଡିଛି. ତା ମୁଣ୍ଡରୁ ହଣା ଚିହ୍ନରୁ ବାମ ଗାଲରେ ଖଣ୍ଡିଆ ହୋଇ ରକ୍ତ ବାହାରିଛି. ତୋତେ କିଏ ମାରିଲା ରେ ବୋଲି ପଚାରିବାରୁ ସେ କହିଲା ଆମ ଗ୍ରାମର ସୁନ୍ଦର କାଲୋ ଉଡିଆରେ ଆଉ ଧାଡ କାଲୋ ଲାଠିରେ ମାରିଲେ. ଶିବକୁ ଆମେ ସୁନ୍ଦରଗଡ଼ ଥାନାକୁ ଡାକ୍ତରଖାନାକୁ ନେଇ ଆସିଲୁ. ଡାକ୍ତରଖାନାରେ ଡାକ୍ତର ବାବୁ କହିଲେ ଯେ ଶିବ ମରିଯାଇଛି. ଶିବ ଆଜ ଦିନ ଉପରବେଳା 5ଟା ସମୟ ଶୁଆରେ ତାକୁ ବୁଢିଆରେ ହାଣି ମାରିଦେବାକୁ ତାର ମୃତ୍ୟୁ ହେଇଛି. So that is how the FIR was also registered against these two appellants.
As seen the FIR, the narration in the FIR and the statement of these witnesses, prosecution for the name of this.
ଲର୍ଡସିପ ପେଜ 98 ଦେଖନ୍ତୁ ମୁଦାଲଙ୍କର ଜମାନବନ୍ଦୀ 98
It's a rule.
So,
Oh, there it is.
we are just coming. We are dictating the judgment.
I don't know. Sorry, Millard, I could not present Millard at the time of call. Item number 6, Millard.
We are taking up this matter now.
Millard, I'm
The
ready.
24.
Millard,
What happened to item 6?
Millard, I received that paperwork, Millard, with the hearing on the Thursday. Millard.
All right.
I'm ready with the case, Millard.
ठीक है.
Good well. Sorry, Millard, again, Millard, saying Millard, I could not remain present at that time.
नहीं present. 6 नंबर कौन का डिक्टेशन को दिया ये जी प्रेजेंट जो लाइव वाली लिखी देवे तादरी इन ऐड कर देवे जे रिसीव मिस्टर नायक सबमिट कर दिया रिसीव द पेपर एंड द मैटर मे बी टेकन अप डे आफ्टर अपन रिसीव कर दिए ना मैं 6 नंबर है अपन पेपर बुक रिसीव कर दिए ना ठीक ऑलराइट सो एनीथिंग यू फर्दर वांट टू से
डिसीजन नहीं
पास अपन किसी कहिबे डिसीजन किसी देबे पास when a matter is entrusted to you, find out some decision. A case or dying declaration ऊपर decision बात किसी actively here हो अपन submission.
And this is, in this case, this is not said voluntarily. All the prosecution witness asked him and he said.
So what do you mean by voluntarily? When somebody is asked who is your assailant and he discloses the name, how do you say that it is not voluntary? ଆପଣଙ୍କୁ ପଚାରିବି ଆପଣଙ୍କର ନାଁ କଣ ଆପଣ କୋଉ ସ୍କୁଲରେ ପଢିଲେ ଆପଣଙ୍କର ଇଏ ଆପଣ ସବୁ ଜିନିଷ ମତେ କହିଲେ how can it be said that it is not voluntary? ଜବରଦସ୍ତି ଆପଣଙ୍କୁ କରିଛି କି ଆପଣଙ୍କୁ ପଚାରିଲି ନାଁ କଣ ପ୍ରିପାରେସନ କରିଛନ୍ତି କି ନାଇଁ କରିଛନ୍ତି ଆପଣ ସାଇଟେସନ କିଛି ଆଣିଛନ୍ତି ଆପଣ ବଢିଲେ ସାଇଟ୍ can it be said that it is under any kind of pressure? Why do you say the deceased was lying there, family members came, asked who is, what has happened, केमती तमर एमती अवस्था होला के तमु कोन कला से कहला जे ई लोक मते एथरे मारला से जाना how can we say that it is not voluntary? But which paragraphs you madam you want हाँ ये जो डिसीजन देजन प्रश्न होची पंचदेव सिंह
हाँ पंचदेव सिंह paragraph 7
paragraph 7 yes
paragraph 10 11
paragraph 7 ने तो सी factual aspect रे लिखा है सेटा dying declaration रो entire thing data बोधे written dying declaration question रे पचराई answer दिया है then तापरे principle कौन थिला what is the principle laid down there
corroboration
paragraph 10
paragraph 10 paragraph 11
either where the conviction is solely based on dying declaration, there is an obligation on the part of the court to consider with extreme care and caution both the dying declarations, so also the evidence of the witnesses supporting. The doctor was examined. The doctor appended the certificate at the end of the dying declaration that the patient is conscious while recording the statement.
That a recording of statement.
Recording এটা ওরাল এটা রেকর্ডিং ଥିଲା ରେକର୍ଡିଂ ରେ ସେମାନେ କିଛି discrepancies ପାଇଥିଲେ this is not available. What about the next one
is variance of in statements of the witnesses para 10
there is variance in the statement of the two witnesses with regard to the exact words allegedly used by the that is also not noticed
and that is the oral last part of this the difference in the exact words of the declaration in this case detract materially from the value of the oral dying declaration.
That is not the case here. ଦି ଜଣଙ୍କର ନାଁ କହୁଛି ଆମେ ସେଇଥିପାଇଁ ପଚାରିଲୁ ଯେ ଯଦି ମନେ କରନ୍ତୁ ଜଣେ କହିଥାନ୍ତା ଯେ କେବଳ ସେ ଜଣକ ନାଁ କହିଲା ଆଉ ଜଣେ କହିଥାନ୍ତା ନା କିଛି କହିଲାନି ମୁଁ ପ୍ରଥମରୁ ଥିଲି ଶେଷ ପର୍ଯ୍ୟନ୍ତ ସ୍ପଟ ରେ ଆଉ ମୁଁ କିଛି ଶୁଣିନି ଏଠି ଯୋଉମାନେ ଡାଇଂ ଡିକ୍ଲାରେସନ ୱିଟନେସେସ୍ ମାନେ ସମସ୍ତେ କହୁଛନ୍ତି ଯେ ଆମେ ଯେତେବେଳେ ପହଞ୍ଚିଲୁ ଇନକ୍ଲୁଡିଂ ତାର 3 ଜଣ ଫ୍ୟାମିଲି ମେମ୍ବର ପଚରା ପଚରି କଲା ପରେ ତା ପାଣି ବି ଦିଆଗଲା ପାଣି ପିଇଲା ତାପରେ ଏଇ କଥା କହିଲା ତା ନେମ୍ ଅଫ ଦି ଆସେଲାଇନ୍ ତ ଆଧିରେ ଇନକନସିଷ୍ଟେନ୍ସି କଣ ଆସୁଛି ଆପଣ ଯୋଉ କହୁଛନ୍ତି ଯୋଉଥିପାଇଁ ଆପଣ ଏ ଡିସିସନ ରିଲାଇଜ କରୁଛନ୍ତି।
ଦର୍ଶନ ଟିମରେ ମୁଁ କହୁଛି ଯେ ସେଇଟା ହଉଛି ଭ୍ୟାରିଆନ୍ସ ସବୁ ଷ୍ଟେଟମେଣ୍ଟ, କାରଣ ପ୍ରସିକ୍ୟୁସନ ୱିଟନେସ ରେ ସବୁ କିଏ କହୁଛି ମୁଁ ଆଗ ଯାଇଥିଲି, କିଏ କହୁଛି ମୁଁ ପରେ, ଏଇ ସବୁର ଭ୍ୟାରିଆନ୍ସ ଷ୍ଟେଟମେଣ୍ଟ ଏକ୍ସାକ୍ଟ ୱାର୍ଡ ସେମାନେ ଇଏ କରିବେ।
Please take your seat. Sit down. Criminal Appeal number 62 of 2002. 2000. You are engaged as amicus curiae by which order? Pandakini Pandang Kro. Acha. ଆପଣଙ୍କ ନାଁ ପ୍ରଥମରେ ଲେଖା ହେଇଛି 24/7/25 ରେ। ଅଠର 11 ପରେ ଯେତେବେଳେ ମ୍ୟାଟର ଆସିଛି 24/7/25 ରେ, during that period ତାର ନାଁ ଆସିଛି। In view of the statutory Swanso is requested to assign the afference a panel advocate. So ତାପରେ ସେଇଥିରେ ବୋଧେ। So you have been engaged, that means by the legal aid.
Not amicus.
Not amicus curiae. ଆପଣଙ୍କର ଥିବ ଅର୍ଡର ଥିବ। ଅଛି 18/11/2021 ଅଛି। ଆପଣଙ୍କୁ ଏନଗେଜମେଣ୍ଟ କରାହେଇଛି ବାଇ ଦି ଏଇଥିରେ ଅଛି, ଏଇ ଯୋଉ ଅର୍ଡରଟା 10 ନମ୍ବର 18/11। You have been engaged by the Orissa High Court Legal Solution. ठीक है। And ये जो alive थिला बेली अच्छी आपण रिपोर्ट आनिचंदी परा कहउचंदी माइल के को order handling which indicate that the both the offense such as 23/9/2025. All right, take down. Appellant number 1 हला सुंदरमणि कालो, appellant number 2 हला रविंद्र का। The appellant so and so his trial in the court of Learned Session Judge Sundargarh in Sessions Trial number 95 of 1995. For offense punishable under section 302 reduced section 34 of the Indian Penal on the accusation that on 23rd January 1995 at 5 p.m. at Durgudi Depot, they committed murder of Sivanath Kalo, bracketry hereafter the deceased, in furtherance of their common intention. ST case number, case trial in the court of Swanso, in sessions trial number 95. Okay. The London trial court by the impugned judgment and order dated 1/12/1999 found both the appellants guilty and the offense charged and sentenced each of them to undergo rigorous imprisonment for life. Stop. The prosecution case, as per the first information lodged by PW2 Lochan Kalo before the inspector in charge of Sadar Police Station, Sundargarh, on 23/1/1995, in short is that is the cousin brother of the, he was the cousin brother of the deceased, and the deceased was serving as a teacher in a UP school at Thippapani. On 23/1/1995, the deceased had been to the school, and while the informant was in his house, he was informed by PW7 Pusit Dandashana that the deceased was lying near a bridge at Durgudi Gipa. In an injured condition. Getting such a message from PW7, PW2 came to the spot where he found the deceased was lying by the side of the road, and there were pot injuries on the head and also injury on the left cheek, bleeding injuries. When he asked the deceased about the name of the assailants, the deceased disclosed before him that the co-villagers Sundar Kalo, bracket appellant number 1, and Dhado Kalo, bracket appellant number 2. Dhado alias Rabindra Kalo, appellant number 2, assaulted him by means of budia and lathi respectively. The deceased was shifted to Sundargarh Hospital, government hospital. However, the doctor declared him dead in the hospital. It is further stated in the first information report that on 23/1/1995 at about 5 p.m., both the appellants assaulted the deceased by means of budia and lathi, which resulted in his death. On receipt of the report, written report from PW2, PW20 Loknath Pradhan, the inspector in charge attached to Sadar Police Station Sundargarh, registered Sundargarh Sadar PS case number 9 dated 23/1/1995 under section 302/34 of the Indian Penal Code against both the appellants. PW20 himself took up investigation of the case. During course of investigation, he examined the informant, bracket PW2 deputed constables to guard the dead body and left the police station, reached at the village Kanaktura and Kanaktura, and visited the spot in presence of the informant, which was Manjermat hyphen
Kanaktura Road.
Road, situated near
Durgudje
Dhipa Bridge, and prepared the spot map, Exhibit 6. The IO also examined some witnesses in the village, and on 24/1/1995, he held inquest over the dead body of the deceased at District Headquarters Hospital, Sundargarh, in presence of witnesses, and prepared inquest report, Exhibit 7, and thereafter dispatched the dead body of the deceased through the constables for post-mortem examination to the District Headquarters Hospital, Sundargarh. On 24/1/1995, the IO also seized bloodstained sample bloodstained stone from the spot as per seizure list Exhibit 9, and examined some witnesses on that day and on the next day. And on 26/1/1995, he seized the wearing apparels of the deceased on being produced by the constable under seizure list Exhibit 10. And on the same day, he received the PM report and arrested the appellant Sundarmani Kalo and recorded his statement under Section 27 of the Evidence Act. And since on the basis of such statement from in presence of the witnesses, the Budia bracketary Acts bracketary MO1 was seized from the house of appellant number 1 as per seizure list Exhibit 2/2. The appellant number 1 also gave recovery of one lathi bracketary MO2 from inside the jungle near the spot, and the same was seized as per seizure list Exhibit 12. The cycle of the deceased was also seized by the IO as per seizure list Exhibit 13, being produced before him by one Dilip Kumar Kalo, who brought it from the spot to the village. The appellant number 2, Dhado alias Ravindra Kalo, was arrested on such and such date, and one Chek Lungi was seized on being produced by appellant number 1 as per seizure list Exhibit 14 in presence of the witnesses, and on 27/1/1995, both the appellants were sent to the doctor for their medical examination and also to collect the sample blood and nail clipping. And then on the same day, both of them were forwarded to on 28/1/1995. The nail clippings of both the appellants and the sample blood, which was collected by the doctor, was seized as per seizure list exhibit 16. The IO made a prayer before the London SDGM Sundargarh on 30/1/1995 for recording of 164 CRPC statements of some witnesses, and accordingly the same was done. Some documents relating to land dispute between the parties were seized. Stop. All the seized articles were sent to RFSL Sambalpur for chemical examination through the London SDGM Sundargarh, and on completion of investigation, charge sheet was submitted against both the appellants under section 302(201) by 34 of the Indian Penal Code. Next para. After submission of charge sheet, the case was committed to the Court of Session, where the London Trial Court framed charges against the appellants, since the appellant pleaded not guilty and claimed the sessions trial procedure was resorted to establish their guilt. Stop. In order to prove its case, the prosecution examined 21 witnesses. The prosecution also exhibited 19 documents, and also proved 6 material objects. The defense plea of both the appellants was one of denial, and it is pleaded that they have been falsely entangled in the case. The London Trial Court, after assessing the oral as well as documentary evidence on record, and analyzing first came to conclusion on the basis of the evidence of the medical officer PW16 that the deceased died a homicidal death. The London Trial Court came to hold that the 2 witnesses who are supposed to be the eyewitnesses to the occurrence, that is PW18 and PW19.
16 doctor man. 16 doctor man.
No, not.
PW18 and PW19 have not supported the prosecution case, for which they were declared hostile by the prosecution. So far as the other witness, that is PW6, though posed himself as an eyewitness to the occurrence, but the London Trial Court came to the conclusion that he, along with others, after hearing the assault on the deceased came to the spot and found the deceased lying injured, and therefore PW 16:6 was also not accepted as an eyewitness to the occurrence. However, considering the oral dying declaration made before the family members as well as the co-villagers, the London trial court came to the conclusion that the dying declaration can be safely relied upon. The London trial court also discussed about the leading to recovery of the weapons at the instance of appellant number 1, Sundarmani Kallo, and came to hold that even though the witnesses have not disclosed the details of the statement given by the appellant number 1 before the investigating officer, the same cannot be fatal for the prosecution. And the report of the chemical examiner exhibit 18 indicated that Lathi MO2, which was recovered at the instance of appellant number 1, was stained with blood. Therefore, such recovery, coupled with the dying declaration made by the deceased before the villagers, clearly bring home the complicity of appellant number 1, Sundarmani Kallo, with the crime. The London trial court further held that when the appellant number 1 had given recovery of the Tangia, it could not be ruled out that it was not used in the commission of the crime. Accordingly, it was held that the dying declaration of the deceased and the recovery of the weapon of offenses, that is MO1 and MO2, at the instance of the appellant 1, it can be said that the prosecution has been able to prove its case against both the appellants beyond doubt. Though the prosecution placed reliance on two panchanamas, that is MO6 and 5 and MO6, but the London trial court has held that no reliance can be placed on those documents to prove the motive on the part of the appellants. Accordingly, it was held that the prosecution has proved that the appellants are the author of the crime and held them guilty under section 302 Y34 of the Indian Penal Code. Ms. Sodamini Panda, learned counsel for the appellant, who has been engaged by the Orissa High Court Legal Services Authority, argued that since the learned trial court has disbelieved the evidence of the eyewitnesses, that is PW 6, 18 and 19. On the basis of the oral dying declaration, which is stated to have been made before PW1, PW2, PW3, PW4, PW7. The London trial court should not have convicted the appellants. The London counsel argued that from the evidence of the doctor, bracketary PW16, who conducted post-mortem examination, it appears that the deceased has sustained 5 injuries on the head, out of which 4 are incised wound and 1 is a lacerated wound. And the doctor has also noticed that there was internal damage to the brain, and he has opined the cause of death due to hemorrhage and shock, leading to coma due to injuries to the vital organ like spleen and compression of brain. It is argued that in view of such assault on the deceased on the head, when there is no material on record that the deceased was in a fit state of mind to make the dying declaration, no reliance can be placed on the evidence of the witnesses who have deposed that the deceased disclosed before them that both the appellants assaulted him. The Land Council submits that in this case, since the 2 Panchanamas have not been given any importance to by the London trial court, and motive on the part of the appellants for assaulting the deceased has not been proved. Therefore, in the case in hand, it is very difficult to hold that the prosecution has proved the charge against the appellants beyond all reasonable doubt. Mr. Sarat Chandra Pradhan Lenin, Additional Standing Counsel, on the other hand, supported the impugned judgment and submitted that even though the eyewitnesses have been discarded by the no reliance has been placed on the evidence of the eyewitnesses by the London trial court, but it appears that the oral dying declaration made not only before the family members but also before the co-villagers are consistent, and no doubtful feature is there in the evidence of the witnesses who have deposed relating to the dying declaration, and their evidence also inspired confidence. And when nothing has been brought out from the evidence of the doctor bracketly PW16 that on the deceased would not be mentally fit state of mind to make any dying declaration. It cannot be said that the London trial court was not justified in placing reliance on the dying declaration. The Land Council further argued that evidence of the dying declaration that the appellants assaulted by two different weapons on the deceased is getting corroboration from the post-mortem report. And the doctor has categorically stated that the 4 incise wound could be possible by sharp cutting weapon, and the lacerated wound, which was noticed, could be possible by the lathi. And therefore, the impugned judgment and order of conviction should not be interfered with. Stop. बाकी असले देखिए लंच पर असले देखिए
Settle.
Adverting to the contention raised by the land council for the respective parties, let us first analyze the evidence on the front as to whether the prosecution has proved that the deceased made a homicide of death. Apart from the inquest report, which has been proved by the investigating officer bracket PW20 as Exhibit 7, the doctor bracket PW16 was the assistant surgeon in district headquarters hospital, conducted post-mortem examination over the dead body of the deceased, which is very relevant. According to PW16, we conducted the post-mortem examination on 24/11/1995 and noticed the following external injuries. He also noticed the following internal injuries. We opined that all the injuries were antemortem in nature and sufficient in ordinary course of nature to cause death. He further opined that the cause of death was due to hemorrhage and shock, leading to coma due to the injuries to vital organs like spleen and compression of brain. The post-mortem examination report has been proved by PW16 as Exhibit 4, and he has stated that the external injuries number 1 to are possible by sharp side of an axe. In the cross-examination, defense has elicited from the doctor that no weapon of offense was produced before him by the IO for his examination and opinion. And he has stated that external injury number 5 could be caused by fall or dash. And that particular injury is also alone sufficient for causing death. Nothing has been elicited in the cross-examination further to disbelieve the evidence of PW16 or the post-mortem report finding as per Exhibit 4. In view of such evidence on record, we are of the view that the London Trial Court has rightly came to the conclusion that the prosecution has successfully established that the deceased died of homicidal death. Coming to the evidence of 3 eyewitnesses, we find that PW 18, Pula Munda, also PW 19, Pavitra Nayak has not supported the prosecution case and they have been declared hostile by the prosecution. So far as PW 6, Pavitra Parkua is mentioned. Even though in the examination in sheet he has stated that he had seen the appellant number 1 assaulting the deceased by means of a tangia and appellant number Ravindra Kalu by means of a lathi. And they caused the injuries on the person of the deceased. And he saw the incident while going to the house of his daughter, and on seeing him and other person with the appellants fled away from the scene of occurrence towards jungle. But in the cross-examination, he has admitted that he did not state before the police to have seen the incident. Rather, he has stated that by the time he reached at the spot, a government doctor of Megdega and PW7, Pursit Dandashana, and a few others had already reached stop. According to prosecution, PW7 is a post-occurrence witness. Therefore, if PW6 reached at the spot after PW7, he cannot be an eyewitness to the occurrence. And therefore, the learned trial court has rightly not placed any reliance on the evidence of PW6 as an eyewitness to the occurrence. So far as the oral dying declaration is concerned, the same has been proposed to by PW 1, 2, 3, 4, and 7. 8 also, and PW 8. So, PW 1, the widow of the deceased has stated that on the date of occurrence, while she was in his house, when Suresh came and informed her that the deceased was assaulted by the appellants while he was returning from the school. PW 1 further stated that when he came to the place and found her husband was lying on the ground, she gave water to him, and that the deceased was able to talk at that time, and he told her that the appellants caused injury on his person by means of lathi and tangia, and she, along with others, brought the deceased to District Headquarters Hospital, Sundar treatment, where the doctor, after examination, declared her husband to be dead. In the cross-examination, she has stated that by the time she arrived at the spot, many persons had assembled there, and from the spot, the deceased was brought to the house in a cot, and from there they brought him. They took him in a tractor to district headquarters hospital. Stop. Though suggestion has been given to PW1 that she had not given water to the deceased and that the deceased was not in sense at the time when she reached there and that she had not asked anything to the deceased and that the deceased had not told her the names of the assailants, but the witness has denied such suggestion put forth by the Land Defense Counsel. Nothing further has been brought on in the cross-examination to disbelieve the evidence of PW1. PW2 is the brother of the deceased and cousin brother of the deceased, and he has stated that he came to know from PW7 about the occurrence and came to the spot. After reaching at the spot, he asked the deceased the name of his assailant, who told him that the appellant number 2, Ravindra Talo, caused injury on him by means of a lathi, and appellant number 1 caused injuries on his person by means of budia, bracketed tangia. And they brought the deceased to District Headquarters Hospital, Sundargarh, and after examination, the doctor declared him dead. In the cross-examination, he has stated that he had gone alone after getting the information about the incident to the place of occurrence. And the place of occurrence was about half a mile from his house. And most of the villagers had already assembled at the place of occurrence by the time he arrived there. Like PW1, suggestion has been given to this witness that by the time he reached at the place of occurrence, the deceased was dead, and that he did not ask anything deceased, nor did he inform him the names of the assailants. But PW2 has denied such suggestions. PW4, PW4 Dilip Kalo, who is the son of the deceased, has stated that PW5, PW7 came to his house and informed that the deceased had been assaulted on the way while he was returning from the school. And when he came to the place of occurrence, he saw 40 injuries on the head of his father, bracketed deceased. And when he asked the deceased regarding the incident, he told him that appellant number 1 caused injuries on his head by means of Budia, bracketed tangia, and appellant number 2 caused injuries on his person by means of lathi. He further stated that they brought the deceased to the hospital, and after examination by the doctor, he was declared dead. In the cross-examination, he has stated that he, along with his mother, bracketed PW1, came to the place of occurrence on foot after getting the information from PW7, and about 50% had assembled at the place of occurrence by the time they reached there. Suggestions has been given to this witness that he had not asked anything to the deceased, nor the deceased tell him anything, and that the deceased was already dead by the time he reached there, but the suggestion has been denied by PW4. The Plan Counsel for the appellant, Ms. Pandado, challenged the evidence of the P witnesses on the ground that they were related to the deceased, and there is every likelihood of telling falsehood. But law is well settled that related witnesses are not necessarily interested witnesses, and in the case in hand, when all the three have consistently stated about the dying declaration and nothing has been elicited in the cross-examination to disbelieve their statement, we are not inclined to accept this submission that the witnesses are to be disbelieved on the ground of their relationship. Apart from that, the evidence of these three related witnesses getting corroboration from the other witnesses who are the co-villagers of the deceased. PW3 Okilo Kalo has stated that in the afternoon on 23/1/1995, PW7 came to his house and informed that the deceased had been assaulted on his way from the school, and after getting such information, he came to the place of occurrence and gave water to the deceased and asked him about the name of the assailants, and the deceased disclosed that the appellants caused injuries on his person by assaulting him. He further stated that the deceased was brought to the hospital, and after examination by the doctor, he was declared dead. In the cross-examination, he has stated that he had seen cut injuries by Budia on the person of the deceased, and that the deceased had sustained 4 cut injuries on his head. Suggestions have been given to PW3 that by the time he reached at the place of occurrence, the deceased was already dead, and that he had not asked anything to the deceased relating to the names of the assailant, and that the deceased did not tell him the name of the assailants, but the said suggestion has been denied by PW3. The PW7 is another co-villager who has stated that on the date of occurrence, he had been to call a doctor as his mother was suffering from dysentery, and on the way, he found the deceased was lying, sustaining bleeding injuries on the head, and the doctor who had gone to see his mother asked the deceased about the incident, and the deceased disclosed that both the appellants assaulted him and caused injuries on his person. He further stated that He came to the house of the deceased and informed his family members about the incident. In the cross-examination, he has stated that he reached at the place of occurrence about 5 to 10 minutes after the arrival of the doctor at that place. And that the doctor told him to inform about the incident in the house of the deceased, and accordingly he came and informed. He specifically stated that he had informed about the incident to the wife and the son of the deceased. He has denied the suggestion given by the Land Defense Counsel that the doctor did not ask anything to the deceased and that the deceased did not disclose the names of both the appellants as his SLN, but the same was denied. PW8 Tinu Naik has stated that after getting information about the occurrence from one Pavitra, he along with other 4 villagers came to the place of
PW7.
PW7. PW7 Purushot na say
Purushot. It is Pavitra.
Pavitra
has not been identified. Pavitra PW9.
PW9. He came to the place of occurrence and saw cut and bleeding injuries caused by means of tangia on the head of the deceased, and they gave water to the deceased, and thereafter he asked the deceased about the occurrence, and the deceased disclosed before him that both the appellants caused injury on his person. And then the deceased was brought from the place of occurrence to his house. Stop. In the cross-examination, he has stated that he got the information at about 4:30 p.m. from Pavitra that the deceased was lying on the road having sustained injury on his person. He has denied the suggestion that nothing was asked to the deceased and that the deceased did not disclose the name of both the appellants as assailant. Therefore, on a plain reading of the evidence of all the witnesses who are the witnesses to the oral dying declaration, we find that not only the witnesses who are related to the deceased, but also independent witnesses who are the co-villagers of the deceased have stated that the deceased was alive and he was able to talk, he was given water, and that he disclosed the names of both the appellants as his assailant. The law is well settled that a dying declaration can be oral or in writing, and any adequate method of communication, whether by words or by signs or otherwise, will suffice, provided the indication is positive and definite. What evidentiary value or weight has to be attached to the dying declaration necessarily depends on the facts and circumstances of each particular case. What is essentially required is that the deceased was in a fit state of mind and that the disclosure was voluntary and truthful. Stop. In the case of Panir Selvam versus State of Tamil Nadu, reported in 2008, bracket with 17, Supreme Court cases 190. The guidelines have been exhaustively laid down with respect to the admissibility of the dying declaration, which are as follows. 1. Dying declaration can be the sole basis of conviction if it inspires the full confidence of the court. 2. Roman 2. The court should be satisfied that the deceased was in a fit state of mind at the time of making the statement and that it was not the result of tutoring, prompting, or imagination. 3. That the court is satisfied that the declaration is true and voluntary. If the court is satisfied that the declaration is true and voluntary, it can base its conviction without any further corroboration. Roman 4. The rule requiring corroboration is merely a rule of prudence. Next, merely because the dying declaration does not contain all the details as to the occurrence, it is not to be rejected. Next, even if it is a brief statement, it is not to be discarded. Next, if after careful scrutiny the court is satisfied that it is true and free from any effort to induce the deceased to make a false statement, and if it is coherent and consistent, there shall be no legal impediment to make it the basis of conviction, even if there is no corroboration. In the case of Babulal and others versus State of MP, reported in 2003, bracketed 12 Supreme Court cases 490, wherein the value of dying declaration in evidence has been stated as follows. Quote, a person who is facing imminent death, with even a shadow of continuing in this world, practically non-existence, every motive of falsehood is obliterated. Stop. The mind gets altered by most powerful ethical reasons to speak only the truth. Stop. Great solemnity and sanctity is attached to the words of a dying person because a person on the verge of death is not likely to tell lies or to concoct a case so as to implicate an innocent person. The maxim is inverted comma with a man will not meet his maker with a lie in his mouth, inverted comma, and say, nemo meritorius presumitor menta, bracket, ends. Inverted comma, stop. Matthew Arnold said, inverted comma, truth sits on the lips of a dying man, inverted comma, ends. The general principle on which the dying declaration is admitted is that it is the declaration made in extremity when the party is at the point of death and when every hope of this world is gone, when every motive to falsehood is silenced and the mind induced by the most powerful consideration to speak the truth. Situation so solemn that law considers the same as creating an obligation equal to that which is imposed by a positive oath administered in court of justice. In the case of Prakash and another versus State of Madhya Pradesh, reported in 1992, SCC 225, dealing with the dying declaration, the court held as follows, quote, in the ordinary course, the members of the family were expected to ask the victim the names of the assailants at the first opportunity. And if the victim was in a position to communicate, it is reasonably expected that he would give the names of the assailants if he had recognized the assailants. In the instant case, there is no occasion hold that the deceased was not in a position to identify the assailants, because it is nobody's case that deceased did not know the accused persons. Stop. It is therefore quite likely that on being asked, the deceased would name the assailants. In the case of Vijayapal versus State Government of NCT of Delhi, reported in 2015 with a bar 4 Supreme Court cases 749, the Honorable Court Supreme Court held as follows, inverted comma vitare. Law is quite clear that if the dying declaration is absolutely credible and nothing is brought on record that the deceased was in such a condition, he or she could not have made a dying declaration to a witness, there is no justification to discard the same. Therefore, the dying declaration is entitled to a great weight and it should be of such a nature so as to inspire full confidence of the court. And the court has to be on guard that the statement of the deceased was not as a result of either tutoring or prompting or product of imagination. The court must be satisfied that the deceased was in a fit state of mind after a clear opportunity to observe and identify the assailant. Stop. Once the court is satisfied that the declaration was true and voluntary, undoubtedly, it can base its conviction without any corroboration. The rule requiring corroboration is merely a rule of prudence. Stop. In the case in hand, as we have already discussed, that number of witnesses have stated that the deceased was alive, he took water, and on being asked, he disclosed the name of his assailants. And those two assailants are none else than the two appellants of this criminal appeal. And that evidence is consistent. We found no doubtful feature in the evidence of oral dying declaration. And it inspires confidence of this court. Though the learned counsel for the appellant stated that since the deceased has sustained number of injuries on the vital part of the body like head, and the doctor has stated that it was the cause of death was on account of hemorrhage and shock leading to coma due to injuries to the vital organ like spleen and compression of brain. But nothing has been elicited from the evidence of the doctor that on receipt of such injuries, the deceased would not be in a position to speak, or that he would not be in a fit state of mind. Therefore, on assumption that the deceased would not be in a fit state of mind, the evidence of the witnesses to the dying declaration cannot be discarded. Moreover, the appellants were known to the deceased and the occurrence happened during daytime. Therefore, the question of the doubt regarding the visibility factor does not arise in this case. Thus, we are of the view that the Lennon trial court is quite justified in placing reliance on the evidence of the oral dying declaration adduced by the prosecution, even discarding the evidence of the eyewitnesses. Stop. The appellant number 1 has stated to have given recovery of one tangia as well as one lathi, which were not produced before the doctor, bracket PW 16, for his examination and opinion. And it is also a fact that these two weapons were sent through fort for chemical examination, and in the axe no blood was found, and in the lathi though blood was found, but there was no opinion relating to its origin or grouping. But all the same, since we accept the dying declaration, oral dying declaration given by the witnesses and the corroborating evidence adduced by the Dr. PW 16, and from the evidence of such witnesses, it appears that it was on account of the assault by the appellants the death of the deceased has taken place. We are of the view that the Lennon trial court has rightly found the appellants guilty under section 302 by 34 of the Indian Penal Code. Accordingly, we find no merits in the criminal appeal, and the same is dismissed. Whether they are on bail,
Lordship.
My lord. The appellants were directed to be released on bail as per order dated Nine one 2004, and it is also reported by the alive asla kebe ame indicate karchu, and it has also been reported by the IIC Sadar Police Station Sundargarh that both the appellants are alive as per the written instruction dated 2/9/2025, which we have recorded in the order dated 23/9/2025. In view of both the appellants have surrendered before the land and trial court within three weeks, failing which appropriate steps shall be taken for their arrest and remanding them to judicial custody to serve out the sentence. Put a note of appreciation on Srimati Mandakini Panda as well as Mr. Prabha. Yes, sir. What about you? 88. Yes, you are.
Yes, my lord. The petitioner has undergone he is on bail and manner under section 302 IPC and passed by the Malkanagiri District Mirror in GR case number 445/2006, PS case number 177/2006.
No, we on the last day when the matter was taken out on 27/2025, we asked the learning council for the state to obtain instruction relating to the avocation of the appellant, the family, and also the conduct of the appellant pre as well as post conviction after being released on bail. That is it. About the family.
The family part is concerned.
एकदम evasive ଗୋଟେ ଦେଇଦେଇଛି ଥାନାରେ ବସିକି ବୋଧେ
ଏଇଟା କଣ ପାଇଁ ରିପୋର୍ଟର ୟୁଟିଲିଟି ଟା କଣ ଆମେ କଣ ପାଇଁ ମାଗିଛୁ
ବସିକି ସେ ଦେଇଦେଇଛି ବୋଧେ
I am talk with him so far the family is concerned there is no family. ତା family ନାହିଁ ସେ wife ତାର ତା ବାପ ଘରେ ରହୁଛି ତା ବାପା ମା ମରିଗଲା ପରେ ସେ
କିଏ ଦବ
ସେ that part has not been given me that's why I am telling that please you give all these things.
ତାପରେ ଲେଖା ହେଇଛି after release from jail custody he is not involved. What about the prior to that? What about the
criminal action limited to that?
ମାନେ ଆମ ଅର୍ଡର ଟାରେ କଣ କିଛି ଜଣା ପଡୁନି କି କ୍ଲିୟର ଅଛି ପରା ଅର୍ଡର ଲେଖା ହେଇଛି ପ୍ରି as well as post ଆଉ ତା କଣ ଏମିତି ରିପୋର୍ଟ ଦଉଛନ୍ତି ଆପଣ?
Every time in fact that giving it to a constable getting a report.
ମୁଁ ଅର୍ଡରଟା ମଧ୍ୟ ତାଙ୍କୁ ପଠେଇଥିଲି ହ୍ୱାଟ୍ସଆପରେ ମୁଁ କହିଲି
ଅର୍ଡରଟା ଯଦି ପଠେଇଲେ ଏଇ ଟାଇପର ରିପୋର୍ଟ ଦଉଛନ୍ତି why are you not bringing it to the notice of the superintendent of police? He is the authority who can take action against him. The order of this court is very clear, but in spite of that, he is not furnishing this report. So communicate to the superintendent that this was the order and he has not stated, and court expressed the displeasure.
Today also that I is also present in this court.
He is the same man.
Same man.
He must have given it through someone.
Same man.
See
Oh,
the
ସେ
language.
ଲୋକ।
ରିପୋର୍ଟ ଦେଲା ପରେ ମୁଁ ତାଙ୍କୁ କହିଲି
ଆଜି ଆସିଥିଲା।
ସେଇ ଲୋକ।
ଏ
ମାଲକାନଗିରି ସେଇ ଗୋଟେ ଲୋକ ଆଉ।
He is there or he has left? ଆଜି ଯୋଉ ଆସିଥିଲା ସକାଳେ।
ସେଇ ଲୋକ।
ନାଇଁ ଅଛି ନା
ସକାଳେ ଆସିଥିଲା ପରା।
ସକାଳେ ଆସିଥିଲା ସେଇ ଲୋକ।
ଟିକେ ସୁନ୍ଦର ଲେଖିଦେଇଥିବ during inquiry.
Whatever he has submitted, that let us say that we alter to 304 part 1.
Yeah.
So we are to sentence him. Now he has undergone about as it appears 2006 ରେ custody ଯାଇଥିଲା 2012 ରେ ବାହାର ଜେଲ ରେ ହେଲା ତେଣୁ ବର୍ତ୍ତମାନ admittedly ଘଟଣାଟା ହଉଛି କେବେ କାରଣ 2006 ମସିହା ତ ପାଖାପାଖି 19 ବର୍ଷ କମ୍ପ୍ଲିଟ ହବାକୁ ଯାଉଛି 20 ବର୍ଷ ନୁହେଁ 19 ବର୍ଷ କମ୍ପ୍ଲିଟ ହେଲା ତେଣୁ ସିଏ ବର୍ତ୍ତମାନ ଜଣେ ଡ୍ରାଇଭର ଅଛି ତାର ଫ୍ୟାମିଲିର ଇଏ ଅଛି ସେ ଅଛି ଏ ହେଲେ ଆମେ ସେଣ୍ଟେନ୍ସ ପଏଣ୍ଟରେ କିଛି କନସିଡର କରିପାରିବୁ ଯଦି ଆମେ ଅଲ୍ଟିମେଟଲି ଅଲ୍ଟର କରୁ ନ କରୁ ତ ଗଲା ଇଏଟା ସେଇଥିପାଇଁ ୟାର ରିପୋର୍ଟର ଇମ୍ପୋର୍ଟାନ୍ସଟା ରହିଛି ଏବେ କି ରିପୋର୍ଟ ଇଏ
ସେ କଣ ଲେଖିଲା now he was working as labor ମାନେ କଣ now ବି was ବି now he was working as labor at hotel and he was doing driver କଣ IAC ପୁଣି certify କରୁଛି
ଅର୍ଡରଟା ପଠେଇ ସାରିଲା ପରେ ତାଙ୍କୁ କହିଲି ମୁଁ କହିଲି this is the order
still
all these things
ବାରମ୍ବାର ଆସିକି ଛିଡା ହେଲେ ସେ କରିଥିବା ତା ଦ୍ୱାରା ହବନି
ये तो पाठ आड़े अच्छी आसीबो पहरदिन
but
we have almost heard him so I think he was pointing out that aspect that it is a case how the thing happened se jo jio asila macho tarkari anigini bappa ku dela ye tar se bode anithila sakalu macho nije pai ye kariyaku join au ଶଶୁର ଭିତରେ ପଡୁନି ତେଣୁ ଇଏ ଆସିକିନି ପାର୍ଟି କରିଛି ବାପାଙ୍କୁ କାହିଁକି ଦେଇକିନି ବାପା ସେଠୁ ଉଠିକିନି ସପୋର୍ଟ କରିଛି ଝିଅକୁ ତେଣୁ ଶଶୁର ଆଉ ଜ୍ୱାଇଁ ଭିତରେ କଜିଆ ହେଇଛି ଇଏ ଯାଇକିନି ଆଣିକିନି ସେ କଣ ଭିତରୁ ଗୋଟେ ଦେଇଛି ଛୋଟେ this is the evidence ତେଣୁ as it appears that and evidence ଯେ ସେ କିଛି ଅସ୍ତ୍ର ଧରିକିନି ଆସି ନଥିଲା ଗୋଟେ all on a sudden ଗୋଟେ ହେଲା ଆଉ ଏଇଟା ଖାଇବା ସମୟଟା ଯୋଉଠି ମାନେ ସେ ଆସିଛି ଦିଟା ବେଳ ସମୟ ବୋଧେ ନା ତ ଏଇ ସମୟରେ ଆମେ ସିଚୁଏସନ କୁ ନେଇକିନି ସେ କହୁଥିଲେ ଯେ ଦିସ୍ ଇଜ ଦି evidence
there is a
provocation part
premeditation ନା
ଏଠି premeditation ଟା ନାହିଁ ସେଇଥିପାଇଁ ୟାର ଇମ୍ପୋର୍ଟାନ୍ସ ରହୁଛି ଆଉ ଏମିତି ଦେଲେ କଣ ହବ
we
are bringing day after tomorrow we are writing that you have submitted the report but again say that this report is not as per the order dated Mr. Naik Lund additional government advocate as per the order dated 27/11/2025 to submitted the inquiry report but we still stated that this report is not satisfactory and not in consonance with the order dated 27/11/2025 and therefore he seeks some time to obtain a further report, detailed report in that respect. As prayed for, place this matter on 4th of December 2025. This is taken on record.
Good one. Jump too much.
आपकी अच्छी
94 my lord. This list 94. I'm more than 12 and a half years, my lord. Up till 2016, my lord.
No, but you must tell to the state
Yes.
council so that
Yes,
they will get ready and you cannot say that ଆପଣ ରେଡି ହେଇଯାଇଥିବେ ମ୍ୟାଟର ଅଛି 94 ରେ
yes, ma'am.
ସିଏ କେମିତି ରେଡି ହେବେ ଆଚ୍ଛା କ୍ରିମିନାଲ ଆପିଲ ଟା ଗୋଟେ ବେଲ୍ ଆପ୍ଲିକେସନ ହୁଏ ନା ସେମାନେ ରେଡି ହେବେ ସେମାନେ ସବୁ so if you are ready till it will be there on the in the list we can take up on that day also.
The IA is live for my
Huh?
IA
IA?
IA 25 is live.
ସେ ତ ଅଛି ଆଉ ରହିଛି ଆଉ ଏଇଟା ବର୍ତ୍ତମାନ ଆପଣ ହିୟରିଂ ପାଇଁ ରେଡି ହେଇଗଲେଣି ପୁରା କହୁଛନ୍ତି ଆପଣ ପ୍ରିପେୟାର ହୁଅନ୍ତୁ କାହାକୁ ଗୋଟେ ଦେଇକି ଯୋଉ 4 ଜଣ ଅଛନ୍ତି 94 ଟା ସେ ରେଡି ଅଛନ୍ତି that is a 2016 appeal criminal appeal. ତମେ ବୁଝିଲ ସେ ଯୋଉ ଇଏ ଗୁଡାକ ଏ ଜେଲ କ୍ରିମିନାଲ ଆପିଲ ଗୁଡାକୁ ସେଗ୍ରିଗେଟ କରିଦେଲେ ତା ଭିତରେ ଦେଖ ଆଇଟମ ନମ୍ବର 90 ଜେଲ କ୍ରିମିନାଲ ଆପିଲ 2008 ର ଗୁଡା ହଉଛି ପୁରୁଣା ଆପିଲ ଗୁଡା ଗୋଟେ 2009 ସେଗୁଡା ସବୁ ତମେ ସେଗ୍ରିଗେଟ କର ତାକୁ ଉପରକୁ ଆଣ ଏ କ୍ରିମିନାଲ ଆପିଲ ଭିତରେ ଗରିବ ଲୋକଗୁଡା ରଖି କେତେ ଜେଲ କ୍ରିମିନାଲ ଆପିଲ ପଶିଛି ତାକୁ ଗୋଟେ ହେଡିଂ କରିଦିଅ ଜେଲ କ୍ରିମିନାଲ ଆପିଲ ଟାକୁ ଉପରେ ରଖ ଯୋଉଥିରେ ମାନେ ଇଏ ହେଇକି ଥିବ ମାନେ ଜେଲ କ୍ରିମିନାଲ ଆପିଲ ୱିଥ କ୍ରିମିନାଲ ଆପିଲ ଥିବ ଲାଇକ ମନେକର ନମ୍ବର ଅଫ ଆପେଲାଣ୍ଟସ ଥିବେ ତା ଦେହରେ କିଛି କ୍ରିମିନାଲ ଆପିଲ ଥିବେ କିଛି ଜେଲ କ୍ରିମିନାଲ ଆପିଲ ଦ୍ୟାଟ୍ ଇଜ ଏ ଡିଫରେଣ୍ଟ ମ୍ୟାଟର ବଟ୍ ଯୋଉଟାକ ସିଙ୍ଗଲ ଜେଲ କ୍ରିମିନାଲ ଆପିଲ ଅଛି ତାକୁ ଉପରକୁ ନେଇ ଆସ ହେଡିଂ କରିଦିଅ ଜେଲ କ୍ରିମିନାଲ ଆପିଲ ତା ନେଇ ଆସ କ୍ରିମିନାଲ ଆପିଲ ସେ ତଳେ ଦିଅ who else are there? What is your item?
My lordship, item number 1.
कौन है ना आपका?
My lordship, in the paper book, do not have the PM report and other annexures, other documents.
PM report तो not है यार तेरे paper book रे as for rules it doesn't contain it but if you want to see because the doctor is evidence must be there
And
बाकी
Caesar
चाहिए
list,
नहीं थी अपन कुछ ना
I can pen drive.
PM report अपन pen drive नहीं जानते
Right.
but you get ready it will be there in the list इटा कौन जो order लिखा है इतना कि नहीं इतना मुझे नहीं the land and council लिख दे बता दे land council for the appellant submits that he has received the paperwork and state has also received the state has received the paperwork ଯାହା ଡକା ହେଇଥିଲା ଆସ୍ଥାବାଦୀ ସେ ପହଞ୍ଚିଛନ୍ତି ବୋଲି ଆସିଥିଲା ତାପରେ
abscond
ହଁ
ଦି ଜଣ abscond ଥିଲେ
One is ଗୋଟେ ଟ୍ରାଏଲ ଫେସ୍ କରୁଛି 2014 ରୁ
ଗୋଟେ ଟ୍ରାଏଲ ଫେସ୍ କରୁଛି ଆଉ ଗୋଟେ abscond ଅଛି
ହଁ ସେଟା ହଉଛି ଯୋଉ ମାନେ ଅନ୍ୟମାନେ
ଅନ୍ୟମାନେ
କାରଣ I think on that day Mr. Mahapatra made a submission that since against those who so also
the
Basant there are allegations suppose in the meantime they might have faced trial and acquitted or but it is not the case of that nature so we'll hear this matter है ना लिख देवे let a land council for the appellant submits that is not having the copy of the postmortem report and this one may be supplied
Caesar
that the registry supply this and when exhibit টা দিয়ে দেবো সেই যে postmortem
PM report.
PM report
all exhibits, all exhibits like Caesar list and all.
अच्छा all the exhibits got them बाकी how की ଅଛନ୍ତି okay ना Mr. Nayak, we are bringing those jail criminal appeals which are in this list to the top. You'll find that there are a number of jail criminal appeals. Those are also of the year 2005-6, but they are down below because this criminal appeal are older than those jail criminal appeals. But we are bringing those jail criminal appeals to the top in a separate heading, of course. And then this jail criminal appeal. जहाँ भी अच्छी चाहे 5-6 जहाँ भी अच्छी तब ऊपर को ठीक हो चुका ये. That will come on Thursday.